prosecution.
No, you may not go to the facts. Whether the learned court has committed error which can be interfered in a revision. As far as appreciation of evidence is concerned.
There are two aspects.
Yes.
The entire substance of the provisions on 498A as well as 306.
Yes.
This is the fact of harassment and cruelty. The
Yes.
finding to that effect had to be given for the learned judge to have come to the conclusion that there is no case. But that finding does not exist at all. He has cursorily gone through all the prosecution evidence and has come to the conclusion without any mention of section 113A and B of the Indian Evidence Act, where the presumption also exists. Although it is a rebuttable presumption, that matter has not been delved into at all. So on materials on record at least show that there was prima facie harassment was there, cruelty was there. That finding is not there. When that finding itself is not there, it was not proper on behalf of the learned judge to have acquitted all the accused. That is my submission.
I mean, which part of the admissible evidence was ignored according to you?
My lords, come to page 6, internal page 6 of
what is Exhibit 5?
My lords.
What is Exhibit 5?
Exhibit 5, my lords, is that one compromise letter.
Viscera report?
Viscera report shows poison. This was suicide by poison. But while the deceased committed suicide, she was in a parent's house for the past 3 months. Therefore, the learned judge has come to the conclusion that there is no case made out for dowry. But the essential factum of the offense, my lord.
So, where is the proximate cause? Because prosecution says 3 months.
My lord.
At parent's house.
My lord.
Then what is the proximate cause?
There's an FIR registered.
She could be depressed because of the past incident.
There's a FIR registered by the deceased.
Suppose the torture is happening today.
My lord.
The person commits suicide after 1 month or 3 months or 1 year. There is a possibility. Even because the continuous, because you see that definition.
My lord. 304B, my lord, I'll come to.
Whatever, whichever substantive the provision defines that offense.
My lords, 304B L first place, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of a husband for or in connection with any demand for dowry, such death shall be called dowry death. So, my lord, I was submitting humbly that she was subjected to cruelty or harassment by her husband. This factum the learned judge had to come to. There has to be a finding on this.
Whether or not she was subjected to.
But that, despite materials on record, he has never given a finding.
No, basically, you take the issues at paragraph 5, page 5.
My lords.
What is 1? For 1 is answered suicidal.
My lords.
Page 4, last paragraph.
My lords. 1 is
death of the deceased, suicidal.
My lords.
Then marriage is not disputed.
Not disputed, my lords.
Then what? 3 has been proved by the prosecution. Demand of dowry.
1,30,000. There is consistent evidence that the demand was made, but that has been discarded completely. I mean, my lord will come to the prosecution evidence itself. Page 6. Page 6, my lords, para 7. PW2, may I place minutes?
No, I'm not going there actually. I'm trying to understand the reason why the learned court has, because there is a difficulty as far as 3 months is concerned. Where he has given that finding.
Well, let's will come to page paragraph 11 of the judgment at page 8. That is where he is summing up everything.
Who is the best witness for the prosecution according to you? Star witness who has proved that demand or torture.
There was the father of the deceased.
Father.
My lords.
To take notice on admission.
My lords.
No delay.
No delay.
But it is pending since last 11 years. That's the difficulty.
After
11 years, somebody's acquittal,
yes.
If it is to be.
I was very conscious of the fact, but I found that, if my lord comes to paragraph 11 for 1 second, let me just look at that.
Paragraph 11 of the judgment.
My lords.
Yes.
Now, he has discussed in the previous paragraphs what all the prosecution witnesses have said, but without giving a finding as to whether they should be accepted or not accepted. Very good.
No, that may not be, but before that, whether he has discussed evidence and arrived at a conclusion.
My lord,
you see, there will be fallibilities as far as the writing of the judgment is concerned. If anywhere, that is how I was asking you.
My lord.
That anywhere he has come to a conclusion. Anywhere he has come to a conclusion that yes, there was.
My lords, may kindly come
demand or no demand.
My lord, may kindly come to page 7, paragraph 2.
Page 7, paragraph 2. Yes.
PW6 states. My lord found it?
Yes.
PW6 states that as per the demand of the accused persons, though dowry articles were given at the time of marriage, thereafter, the accused persons demanding cash of 1,30,000 rupees as dowry started torturing Lima physically. She having stayed at her parents' house. The witness is not specified for which purpose the demand for cash was made. That is not important. The demand was made, that is important. That has not been contravened, not been demolished. Again, second, PW11 states, at the time of marriage of Lima, as per the demand from the bridegroom side, though the father gave 50,000 rupees to a cost of motorcycle, 5 horis of gold and other household articles.
Let us call for the LCR, let us see.
My lords.
Because what is the cross-examination, he doesn't discuss.
My lords. That's the reason, my lord, I was saying that he had to come to a finding from the totality of the evidence where those elements have been satisfied in 304B and whether the presumption under 113 has been rebutted. The judgment is completely silent. So, my lords, 11, I was saying that he says that the above being the totality of the prosecution evidence on record, on the discussion analysis made thereof, it is seen through the same that the prosecution has not been able to establish the charges, offences under sections 498, 304B.
Basically, what has weighed in his mind that he was not with them.
He was not with them.
So, the proximate cause of death,
my lord,
he could not satisfy himself.
That cross-examination actually.
There will be amount of subjectivity.
My lords, the suggestion said there.
Either you prove it. You see, you say that your case is that as prosecution that for the past 3 months there was no torture.
Because he was at a parent's house, so there was no COVID. But there was an agreement that was entered into by both parties where the husband had specifically written that is on exhibit that he is to take back the wife and not indulge in any other quarrels.
You see, that's not torture. That I was what I told you that she may be depressed being separated. Though I did not tell in so many words, but she was depressed being separated. But that's not 498A.
My lord is right. What reveals in the
FIR? Desertion is not a 498A 304B.
What reveals from the FIR is that after that, she went back for some time. But it was again thrown out. That aspect has not been discussed at all.
That's not there.
That's not there. But it's not there at all in the judgment anyway.
Because desertion is not part of, to my humble understanding, desertion is not part of that 498A or 304B. It's not.
Evidence, my lords, does not.
Because desertion is something very civil liability, Hindu Marriage Act and whatever restitution and all that.
My lord. There's an overt act committed which says specifically the allegation is she was thrown out by the husband and his relatives. After the demand for dowry was not
that happens, but it has never been criminalized. At least that is yet to be criminalized. Throwing the daughter-in-law out of the matrimonial home is yet to be criminalized by the legislature or any statute.
The purpose, my lord?
For obvious reasons. Because when that Justice Avadh Rohtagi, they said that bull in the China shop. Because more and more you criminalize the matrimonial relations, more and more it becomes fragile.
That is true. My lord, but the interesting aspect is that
they may fight it out. There will be exchange of blows and shouting and all that, but you criminalize that. DB, the Domestic Violence Act, is there.
My lords, that is
one of the reasons of that more and more penal statutes
My lords.
have increased the number of reporting of criminal cases than any kind of deterrence as far as, because that worsens the relationship, human beings relationship. Perhaps that is the reason why it has not been criminalized, and it has been dealt with by sufficiently restitution of conjugal rights, and so then it's a ground for divorce. Yeah, see, there is maintenance, 125 CRPC maintenance is there. I mean, it's not that, you see why it is silent, why the legislature or the entire statute or those gamut of laws are silent regarding that. There is a purpose.
See, lodged the FIR, my lords, on 28, 2009. 1 month thereafter, she committed suicide. And the FIR is very detailed. Of course, the LCR is not there. So my lord may call for the LCR. Her own FIR.
FIR causes much more discord than it solves problem. But somehow that has caught imagination of people, and with greatest of respect also lawyers, that lodging a FIR against in-laws has caught imagination of people. That's day in, day out. There's no point. I think after 11 years to issuing notices also dragging them into, problem.
That is what I could understand from the matter, my lords.
I don't know why it was there. I cannot ask you. I'm not blaming you that it has not been taken. That's part of our responsibility to take up the matter. Let it come next week. You think about it.
My lord.
Whether it's a fit case, and then you have to prove beyond reasonable doubt. It's not preponderance of probability.
That is true, my lords.
But when they provided you the brief, they have not provided the depositions.
The depositions are there. The depositions are there. I mean, of course. I mean,
in cross-examination, I would request you to just examine the cross-examination.
I have. There's a different case made out, unfortunately, which has not been at all. There's no word. There's not whispered at all in the judgment. That's the strange part.
No, it was presented by the prosecution.
My lords. The deposition is there. I mean, he has discussed the evidence with the cross-examination for some reason and not discussed. Because if he had discussed the cross-examination, the case would have been very clear as to why he was not with the prosecution.
According to you, the cross-examination would help.
Yes, it would help.
Would have helped him. Yes. A return of judgment of acquittal.
Yes,
he would have returned a judgment of acquittal.
Yes.
Then let us not issue notice.
I am being fair, my lord.
Yeah, you have to be. You have to. It is an onerous responsibility,
my lord. It's a very clear case made out. For some strange reason, if you would have discussed the cross-examination, you could have demolished the cruelty and the harassment part, and it would have gone completely.
Mr. Devasis Naik, AGA for the state. Opposite party blank. The petition has been filed seeking leave under section 378 into bracket English 1 Roman 3 of the Code of Criminal Procedure 1973. No, I would have adjourned for that purpose only.
No, my lords, then
because if I call for the LCR after 11 years, I'll go through it and I'll not be satisfied that they have made out a case. That's the point. Basically,
what I have with me is the certified
copy. Yes, the deposition is enough. Deposition is enough because the prosecution case is that it's a suicidal. It could. I mean, she was depressed because she was detached from she was driven out. Prosecution could have made out a case. But why he has not discussed the evidence? As you said, I was just going through and I could not find anything.
Very detailed. In fact, the examination in chief may be only 4 paragraphs. The cross-examination much more exhaustive. Suggestions galore. I mean, very, very different case made out.
So and so section likhile, challenging the judgment oblique order of acquittal dated so and so, passed by so and so. The prosecution case in brief is that paragraph 3 of the petition. On 28/2009, the deceased lodged a written report up to 4 DP Act. The learned AG, referring to the judgment passed by the learned trial court, submits that the The order of acquittal is unsustainable as it is against weight of evidence on record and having been passed without due application of judicial mind. The learned counsel for the learned AG referred to the various paragraphs of the judgment wherein the evidence rendered by the PWs have been discussed. Paragraph 4. 14 witnesses were examined on behalf of the prosecution. Then reproduce that. The learned trial court framed the following issues for determination. Paragraph 5. The learned court, after discussing the medical evidence and the other circumstances, has come to a conclusion that the death of the deceased was suicidal. Thereafter, the learned court has discussed the evidence to bring home the charge alleged, that is under section 304-B, 498A, and the allied offenses as indicated. This court has the occasion to refer to the cross-examination of the prosecution witness, particularly PW 9, 13, 11. Serial time change karte hai. 9, 11, 13, 6, 9, 11, 13. And also noticed the examination in chief of PW 3 and 4, where they did not support the prosecution case as far as demand of dowry is concerned. Mr. Naik?
Correct.
That's your case. 3, 4 did not support?
Did not support.
9, 6, 11, 13. I have examined the cross-examination, but that doesn't support the prosecution case.
My lord.
Yes. The learned AGA fairly referred to the cross-examination of the PWs 6, 11, 6, 9, 13, 11, sequence. After going through the examination, the statement, the evidence of the PWs, these PWs, in considered opinion of this court, the finding given by the learned court acquitting the persons cannot be faulted with. This case is not, in further opinion of this court, no case has been made out for grant of leave to appeal. The petition is disposed of accordingly. Yes.
It's difficult, my lords, in such cases to actually come to a definite conclusion. So it weighs up.
No, initially my perception was little bit, if I Sota was there last day, but today's is not. Petitioner none, opposite party blank rakhiwe. None appears for the petitioner when the matter is called. To grant further opportunity, list on.
एक बार
1st of December 2023.
Item 3.
3 डाकिले ना आपण 3 is the first matter.
Okay.
4,
Item 4.
Mr. Himanshu Shekhar Mishra for the petitioner. Mr. Devasis Naik, additional government advocate for the opposite party. The learned counsel for the petitioner submits that despite his efforts, he has not been able to get any response from the petitioner. The matter was filed in the year 2002. By the no interim order was granted. The interim order was refused by the court, by this court, by order dated 14/11/2012. In view of no interim order having been passed, the proceeding, that is S.C. number 60 of 2020 of 2012, pending before the learned additional session judge Balangir, would have proceeded further and the proceeding would have concluded. Received na return ता कौन है लाजे? Note रे जो लिखा है जे LCR was received or returned. तो पढ़ी पाऊँ नहीं देखी बे? कोड आप को पेज एटा नोटिंग टा देखो तो ऑर्डर नंबर 11 पर है. LCR थिले अपन नोटिंग देता है. को जाए कहले? आपण प्रथमे आसिला 25 4 20 23. The LCR, the lower court records have been returned on 25/3/2021. जो आपण आगो मेमोटा पकोचंती 25 दिन तळे दस्तखत करचंती 19 दिन एटा कोन इंप्रूव करी हबनी? आपनकर आंसर हैला जे सेटा इश्यू हैला परे नंबरटा पडुची बुझिली तल सेटा तळे लेखु नांदी काई जण जण पढी जीवो आगो 19 दिन देखिबो ना आगो 25 दिन देखिबो मोटा सजेशन नंबर 10191 dated 25/3/2021. Mr. Naik, no stay was granted in 2013. After almost 8 years, LCR has been returned because that's a policy now. We are not retaining any LCR. So nothing remains. The learned AGA refers to Asian resurfacing citation ta debe. Asian resurfacing bahar kar debe court mane net true. To submit that after the order passed by the Honorable Supreme Court, in almost all the matters where stay has not been granted, public where the proceeding had been stayed, in all the matters where the proceeding had been stayed by interim order or due to calling of LCR, have proceeded to be concluded. Considering the submissions of the learned counsel for the petitioner and the learned AGA, the petition is disposed of.
Item 5.
Yes, please.
Item 5, no instruction.
No instruction.
No instruction, madam.
What is the matter?
Actually, it's a criminal revision.
The Parida, what can be done? So,
Instruction is yes, that is stay passed by this honorable court.
Stay was granted.
Stay was granted.
So,
And
but
essence-
now after ACN is surfacing twice ordered, the two orders by the Supreme Court, in fact, they have
Yes.
proceeded. Can you obtain up-to-date instruction? What is the present status?
Yes, Manas, I can.
Because most of the lawyers are finding it difficult to contact the person.
Yes, Manas. I need some time. The Essential Commodities Act, it was initially, and that was quashed by this honorable court.
Yes.
Criminal in the same incident manners. Since that was also a ground taken in this case. And now the criminal proceedings is pending and stay has been given by the CJM. He has discharged 3 of the accused. And
But the connected matter, when they say that it is, they have no instruction, then what would happen to this matter?
I don't know what has happened.
You obtain instruction.
I'll
You also try to obtain instruction.
Yeah, definitely.
Because you see,
Jena.
R.A. Jena.
A Jena.
I'm so sorry. A. Jena. ଆପଣ ସେଟା ଟିକେ stem ଟା ଉଠେଇଲା ପରେ ଆପଣଙ୍କ height
Yes.
A. Jena on behalf of Vigyan Kumar Sharma for the petitioner. Mr. Devasis Naik AGA for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions. As prayed for, list on
11/12.
11th December. Per day.
Manas.
You try. So I understand what is the plight. In fact, in service matter, that there is no mobile number. Here there is a lower court counsel. In service matter, there is no mobile number. He becomes completely incommunicado.
Yes, I'll try my best.
Second sub-item, Mr. Sandeep Parida for the petitioner. Mr. Devasis Naik. Same order.
Manas.
Yes.
Item 6.
Deeply obliged, Manas.
Yes, please. Mr. Jagabandhu Sahu for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner fairly submits that by exflux of time during pendency, the matter has been rendered infructuous and nothing remains to be adjudicated before this court. Having heard the learned counsel for the petitioner, the learned AGA, the petition is disposed of.
Item 7.
Mr. Jagabandhu Raut. Mr. Jagabandhu Raut for the petitioner. Mr. Brief देखचें निकाली. Always spend some time with the brief. Withdraw Kolevi, that's the best time you can read the brief also. On behalf of Bharati Das for the petitioner, Mr. Devasis Naik AGA for the state. And counsel for the petitioner submits that as per the instructions of the petitioner, the matter is not to be further prosecuted. The petition is disposed of accordingly. Yes.
Item 8.
Pardon, my lord, I'm on VC, my lord. My lord,
Yes,
my lord, on behalf of Mr. G.K. Mahan,
But I mean, don't be apologetic why you are on VC. Yes, please. Next. Yes, sorry, I'm sorry. Yes, carry on.
my lord, the matter has become infructuous, my lord.
Your name is not there. Mr. S.K.
Malana.
Naik on behalf of Gopal Krishna Mahanti for the petitioner. Mr. Devasis Naik AGA for the state. Learned counsel for the petitioner submits that by flux of time, nothing survives for adjudication before this court in the present petition. The petition is disposed of accordingly. Yes, next.
Item 9.
To be called again at 2. Yes.
Item 10.
To be called again at 2 p.m.
11.
Same order. To be called again.
12.
To be called again.
12, my lord, permitted to withdraw.
Mr. Achyutananda Patnaik for the petitioner. Mr. Devasis Naik, additional government advocate for the state. The learned counsel for the petitioner files memo dated
Today, man.
13/11/2023 containing the instructions stating that as per the instructions from the petitioner, he doesn't want to proceed with the matter. Accordingly, the petition is disposed of. Yes.
13th,
Be called again. Yes, please.
14th,
Yes,
May I please?
Mr. Marana.
Yeah, my lord, petition already been acquitted from the charges.
Details दियंतु sir. Same difficulty. आपण माने कहउचंदी मु गोटे
Instruction was given to the state council to take regarding stage
sir,
of
why how can you see as such the burden on the state council is that he is having so many briefs.
last again it has been given.
Is it so?
Direction was given, my lord, for taking instruction regarding stage of trial.
Non-appears for the petitioner when the matter is called, standing counsel shall accommodation obtain case diary instruction, stage of trial. So how does it help you? I thought that you are saying that after you mentioned he has been acquitted, he was
I
directed.
have taken instruction from the
Sir, give the details. Please make little endeavor. No difficulty in passing out the matter. But at least give the date of order, the court and the case number.
simply permitted to withdraw, my lord.
No, that I will not do. Sir, either you may file a memo for withdrawal, that's a different thing.
Yes, I am,
But
I'm giving them.
to be called again at 2 p.m. Mr. 17, Mr. Bikram Kesari.
17th,
My lord, 17 and 18 after launch, my lord. I am now preparing the affidavit as your lordship is directed.
Sir, you preparing the affidavit, you have to serve it.
Government को दे दी से खाली कितने टंका your lordship directed me.
Please appreciate if they can obtain instruction from the whatever they have to take instruction. It's not an empty formality. So allow them some time. So why to keep it pending? Let it be urgent at least 10 days so they can obtain instruction.
And next week is out.
Yes.
As your lordship please.
Mr. Bikram Kesari Mahanti for the petitioner. Or you have auspicious time for passing of the order, then it's another thing.
There is no.
So this time is fine.
Because
So that order can be passed.
That is not the
So,
way. Fact
Mahanti,
that your lordship
adjournment
directed
order-
chance.
Sorry? No, I will record your submission.
My lord.
Anyhow, because since paperless you can't file it here. We have difficulty in that.
Today I will file.
If you are filing here, how will you update the brief?
Yeah.
Mr. Devashish Naik, AGA for the state. This is item 17.
Okay.
I could have passed over it. The learned counsel for the petitioner submits that
File the affidavit.
he has instructions to file affidavit on behalf of the petitioner. As for his submissions noted in the order dated 5/10/2023, the affidavit be filed within 2 days. Copy be served on the learned AGA for the state to enable him to obtain instruction. List on Aji Ketela. when do you want, Mr. Mahanti?
As your lord.
28 or 23rd? Ko week re kouchanti? 20 week na 28 week re?
Kodio Igresh.
List on 23rd. In these matters, why they will object? Because you
There
are
is nothing to
volunteering to deposit something. They
Your
will say that
lordship,
yes,
your lordship directed me.
yes.
File an affidavit what amount will you pay and what amount by property security.
Sir, I am not directing that.
Oh, there is the order to take instruction.
So you take
By me.
instruction, you
Yes,
volunteer, seek indulgence.
Yes.
That's the short point.
And,
So that has been followed. That's the way
No,
it has been done by my predecessors of this assignment. So that I'm simply following. Once that has started, then why you are not doing? I mean, I'm asking that why are keeping it pending for that?
I have to take instruction.
Yes, you
Otherwise,
do it, do
I
it.
would not have filed that.
2 days time given, you do it and file it and serve a copy.
Okay. Your lordship posted it to 23rd.
23rd?
Okay.
23rd
Yes.
पहले तो?
Yes.
23rd.
Okay.
18th,
18, 17, 18 same order.
17, 18 same.
18 dot date केबे ହେଇଥିଲା को order को दिन କହିଥିଲେ ଆପଣ comply କରିବା ପାଇଁ को order ଟା
ଆଜି ଥିଲା date.
5/10
ହଁ 5/10 ହଁ 5/10 order.
ଠିକ ଅଛି
Same.
19th,
May I please, my lord?
yes Mr. Khara Mr. R.R. Patnaik for the petitioner, Mr. Devashish Naik AGA for the state, London counsel for the petitioner being present at the virtual court Odisha High Court Koraput at Jaipur addresses arguments hybrid mode election yes
Sir, senior is,
Mr. Patnaik
sorry, sir, senior is out of station due to health reasons,
the
sir.
London counsel for the petitioner seeks accommodation. due to non-availability of the arguing counsel as prayed for. List on when do you want?
After 1 month, my lord.
Masse kouchunti.
14
the Lord DG submits that he has received the up-to-date case diary. Yes, next please.
20.
Lordship,
careful.
pray for 1 week after.
Your name, sir?
Brajabhushan Sahoo, Lordship.
Mr. M.S.Sahoo for the petitioner. Mr. Devashish Naik AGA for the state. Same order as 19. Date keve? 30/11. Yes, Mr. Sahoo. 30/11. Yes.
Cool.
You have case diary, Mr.
My lord.
The Lord DG submits that he has received the up-to-date case diary. Has received the case diary.
Pardon me, Lord. Item 16, my lord.
Okay. Yes, next. All matters have been passed over to be taken up at 2 p.m. Usual. Yes.
21.
To be yes. To be called again at 2 p.m. Yes.
22.
To be called again at 2 p.m.
23.
23, Mr. Sahoo.
Pray for
Mr. Divyajyoti Sahoo for the petitioner. Mr. Devashish Naik AGA for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments. As prayed for, list on 1st of December.
Yes, ma'am.
1/12/2023.
I'll have to call for the CD. It's not.
You are not received.
Not it.
The Lord AG shall obtain the up-to-date case diary. Public instruction, public stage of trial. Yes.
I'm supplying the requisition copy of some.
Yes, you give him. But the problem is that you are taking so much of time.
Yes, ma'am.
By the time after 2 months, he will again obtain up-to-date case diary, and some 5-6 more witnesses would have been examined. The learned counsel for the petitioner submits that he shall provide copies of the depositions of the PWs as examined till date on the learned counsel for the petitioner, learned counsel for the state, the learned AGA, to enable him to obtain instruction. Yes, next.
24.
Wait, please, Your Lordship, my lord.
Yes, please.
My lord, the petitioner is in custody since 2/6/2023. Last occasions, I have to take instructions whether he is ready to secure the amount which has been alleged to be frauded. I have taken instruction. The father said, my lord, the account to paisa account total.
You try to file that affidavit. By stating so in court, there's no point. I mean, that's not your part of your.
My lord, yes, I'll do that. What I'm submitting, Lordship, the total 1,50,000 account rupees has come to this petitioner's account.
Sir, it's not question of total or subtotal or percentage. That's not the case. To obtain instructions and file affidavit. In terms of his submissions on behalf of the petitioner, as noted in the order dated 6/10/2023. As prayed for, list on
1 week after.
20/11. Now, further time.
Na 20/11 tha.
20/11. The affidavit we filed, copy be served. But they have to obtain instruction. Upon the file karibe gड़ेबे. तापरे कहबे जे list करा जाऊ.
No, my lord.
Copy be served. List on 28/11.
My lord, 28/11.
See, Mr. Mahapatra, you should have filed the affidavit today, so that it could have been listed on 13.
My lord, may fix to any day after 28, 30.
Yes, list on 1/12, 1st of December.
Yes, lord.
You file and serve the copy. Yes, next.
Oblige, lordship.
25.
To be called again at 2 p.m. Next, please.
26.
Item 26 and 49 pray for 1 week after.
Bhaktilata Bala on behalf of Manoranjan Padi, M.S. Bhaktilata Bala on behalf of Manoranjan Padi for the petitioner, Mr. Devashish Naik, additional government, Mr. Standing Counsel, Mr. S.S. Mahapatra, ASC for the state, the learned counsel for the petitioner yet again prays for adjournment. As prayed for, list on 4/12/2023. The learned ASC submits that case diary has been received.
Hello, CD, sir.
Yes.
27,
Mr. Parthasarathi Das for the petitioner. Mr. Standing Counsel for the state. Case diary and 164 statement.
No, that has not come.
The learned Standing Counsel seeks for further accommodation to obtain up-to-date case diary and the statement of the victim recorded under section 164 of the CRPC. As prayed for how much time, Mr. Standing?
10 days, Your Lordship.
As prayed for list on 28/11. Or you want further time, Mr. Das?
Only prayer, my lord, but this is the 5th or 6th occasion.
It has to be that way, sir. Till hopefully there will be only one case, no crimes will be committed, no allegations will be there. That's the difficulty.
Generally comes. It can as soon
We'll take. Sorry.
Yes.
28,
To be called again.
29,
If it may please your lordship.
Yes,
Your lordship, the petitioner is in custody since 11/1/2023. The offences as per the FIR are under sections 498A and 302 IPC. Your lordship, in the
Case diary is there. Mr. Manish Dhir for the petitioner. Mr. Standing Counsel for the state.
My lord, city is not there, my lord. I'm sorry.
The learned Standing Counsel submits that she has to obtain the case diary and the up-to-date status of case diary, up-to-date status of the investigation, considering the nature of allegation. List on 30/11 or December?
December, your lordship.
December date. 7/12, 7th of December.
Yes, your lordship.
Yes.
I'm much obliged.
Mr. S.S. Mahapatra, AC. Yes.
item 30,
Your lordship.
To be called again at 2 p.m. Yes.
31,
Yes.
Case under section 307 and other allied offences. My lord, custody since
Past allegations.
allegation is
criminal
that
antecedents.
Affidavit is there.
No, my lord, he has not filed.
the court has
Affidavit by one Rasmita Behera, wife, 8/9/2023. According to your instruction, you have received any instruction regarding past allegations?
Yes, my lord, 2 criminal antecedents, my lord.
What you have to file? You have to update your affidavit.
my lord.
The Mr. S.S. Rai for the petitioner, Mr. S.S.
In that
Mahapatra.
regard, my lord, I have filed affidavit.
You are stating that you have no antecedent. On the face of it, it has to be rejected.
Yes, my lord, 2 criminal antecedents. I am giving the reference, my lord,
Except
note of it.
including these two and excluding these two.
No, you have not filed it. Solved the copy of affidavit.
I'll file fresh affidavit.
The learned counsel for the petitioner submits that he will file a further affidavit, though affidavit dated 8/9/2023 is on record filed by the wife of the petitioner indicating that he has no other criminal case pending against him
Except the present one.
except the present case. How much time, Mr. Rai?
Pardon?
How much time will
Next week, your lordship may call.
let the affidavit be filed by 2021/11/2023. Copy be served on the learned ASC to obtain instruction. List on 30
By then,
or December. When do you want?
November, my lord, this month. Next week, your lordship may call.
No, you have to. You have not filed the affidavit.
My lord,
If I am taking up your affidavit, then your prayer has to be rejected.
no, yes.
May I submit, my lord?
Yes.
By then the case diary was received, my lord. Charge sheet was not filed, but here in the meantime, charge sheet must have been filed.
Yes, yes,
because
charge is filed.
Charge
Then-
sheet to
then instead of
I
moving here,
request,
you
my
could have
lord.
moved the learned court in session of the matter.
Yes.
Because in the change circumstances, you are missing that opportunity.
Learned court will not enter in, my lord.
That is no
the
presumption,
normal
sir.
practice.
That is no presumption. So obviously, for after that, you have to
My-
come to this court.
My sole submission is, my lord, he is custody since 26-23.
You see, the
Yeah,
in the circumstances of the case, yes, it may be more or it may be less, but that's a consideration. If taking into the entire thing into mind, the court has to consider if there is any criminal allegations, how he has been utilizing the liberty granted earlier,
My lordship may keep it to some other day.
Yes.
I'll file the affidavit.
or there is a condition that whenever he is released, he will come again indulge in such kind of offences. I will direct. List on 30/11/2023.
30th 11, so let's
30/11.
oblige.
30
Obliged.
Pardon, my lord.
32.
Item 30. Password.
2 p.m. All matters have been passed out to 2 p.m. No adverse order. Yes.
Item 32.
To be called again at 2 p.m. Yes.
34.
33.
33, madam. On the Mr. Bharat Jali, madam. Tomorrow I will file the charge sheet copy.
Mr. Mahanta. Sir, your full name, I'm just.
Srikant Mahanta.
Mr. Srikant S. Mahanta for the petitioner, Mr. For Bharat Jali. You don't have power here. You are on behalf of Mr. B. Jali for the petitioner. The Learned Counsel for the petitioners seeks accommodation to comply with the order dated 26/9/2023 to file the copy of the charge sheet. To place on record the copy of the charge sheet, which is stated to have been filed on 15/9/2023. As prayed for list on. When do you want, sir?
Tomorrow I will file.
Sir, you are not filing, sir. I am not asking, sir. When do you want the listing? Upon to down sir.
Next.
No, 28/11.
34.
34, 35, same also.
Same order.
35.
37.
Same order.
Obligement.
36.
To be called again at 2 p.m.
37.
To be called again at 2 p.m.
38.
Yes.
There's an application for extension of the.
No extension will be granted. Rejected. No extension. No extension, sir.
No, because of the examiner.
Haji surrendered or not on the date?
No, sir, date is 15th.
So,
15th
no extension can be granted.
No, because the exam is on 19th.
Whatever it may be, that is not the ground taken then.
No, that was not published. It was published on 18th.
So no extension will be granted.
1810.
No.
He came to know on 1810.
What is the IA number?
IA number, my lord, 11468.
You have soft copy?
Yes.
1468, my lord.
That was uploaded. He got the admission certificate also.
my lord. No.
The ground for extend after the petitioner was granted interim bail in IA number 1176 of 2023. By order dated
1710.
1710. 17/10/2023. The period of bail is expiring on
from the date of release.
Don't file anything here. It's a paperless court. I cannot take it up. ଆପଣ ଏଟା କ'ଣ ଆଜି ଫାଇଲ କରୁଛନ୍ତି?
ନାଇଁ already I filed. ଆଜି admission certificate ଟା ପାଇଲେ ବୋଲି ଦେଇଛି.
No.
ମାନେ admit card ଟା ଆଜି ମିଳିଲା.
No.
They have uploaded the admit card.
You wait till you get 19/10/2023 as per the order passed by this court dated 17/10/2023. This is on 19/10. Order dated 1710. 1510. The petitioner, the ground for seeking for interim bail, as stated in the petition, is that the petitioner wants to appear at the Odisha Municipal Administrative Service Group A-B examination to be held on 19/11/2023. What is the date notifying the examination?
1911.
Sir, where is that page?
Annexure 3.
Page, sir. Which page? Where is the date? Kindly show that, sir. Annexure 3, Annexure 3, you have told thrice.
To the present miscase.
Whatever, sir, you tell the state away, come to the page where it is mentioned.
Yes. That page. Page अच्छा हो रही है. Page 7.
Please find out where it is mentioned. In page which annexure, where it is mentioned. Annexure, sir, we are holding something wrong brief.
Yes.
Your annexure is not page 7. Upon copy, you are not having that copy.
महापत्र टिके कॉपी देखली.
अपन जोड़े से देइथिले फेरेले तो.
हां सर. Yes sir. महापत्र टिके कॉपी.
The learned counsel is unable to point out where the date of examination is indicated in the IA as per the annexures public notification enclosed.
In the notice dated 1810.
Sir, exam dates, sir, kindly find out the page. You are searching. Initially, you went on saying that annexure 3, fast order, you interrupted that the child has not been delivered. Now I am waiting for you and you are not telling where it is mentioned the date of examination. Sir, you are arguing without a brief even.
I have missed that page.
To be called again at 2 p.m. Next. Yes, please. Next.
39.
Let it come tomorrow, my lord. My lord senior has no brief. Let it come tomorrow.
Page 15.
Sir, what can be done? He is so confident that he is unable. He is interrupting the order to be passed even.
No, my lord, sorry.
Sir, you are going on. You are going on endless.
Page 15.
I am waiting for you, sir. Sir, which page 15, sir?
Page 15 of the miscase.
Then how much time you have taken?
Sorry.
Sir, why you are sorry? Don't be apologetic. There is nothing to be sorry. Why should you be sorry for whatever?
Miss that page.
Sir, you are not having the brief. You are saying that you are page. You said page 7. So I said that there is no page 7.
Sorry.
Then page 15. It is notified on It is notified on
1810.
1810.
Yes.
When the interim bail was granted?
1710.
You obtain instruction.
My lord, I will.
You obtain instruction from the PSC if
My
a
lord.
person is in jail custody,
My lord.
whether he can appear at the examination. I think there is no
From the
restriction.
custody or not, my lord.
Sorry?
Whether he can appear, my lord, from custody?
From custody also? Or, yes. The Lord ASC shall, the copy, ଆପଣ copy ତାଙ୍କୁ ଦେଇଛନ୍ତି ନା ତା ବି ଦେଇନାହାନ୍ତି? ଆପଣ copy ଟା ସେ ନେଇଗଲେ କି?
No, my lord, I have written my.
The Lord ASC shall obtain specific instruction from the Odisha Public Service Commission regarding the possibility, eligibility of the petitioner appearing at the examination. And also whether the petitioner has complied with the terms and conditions imposed by the learned court in season of the matter when he was granted interim bail. You also obtain that instruction whether he has complied with those terms and conditions.
Maybe
Yes, next.
taken upon 17 lordship.
Today is 13.
My lord.
Exam is on
Your Lordship,
19.
Your Lordship will adjourn this matter to 15th.
No, I have not adjourned that matter to 15.
All other cases.
I was rejecting, but
All-
after watching your helplessness, I am keeping it adjourned.
All other cases are there on 15th.
No, whatever it may be, 15th, that's another thing. How he will obtain instruction, because it is you are praying for bail to appear at the examination. If it is placed on 15th, then you should have waited till 15th. But if you have filed that, you have to be serious in pursuing that. 17th Rasu. Yes, next.
39. 39, my lord. After obtaining no objection from the previous counsel, my lord, today I am appearing this case and I have also prepared.
Let me check the order, sir. Your name, sir?
Sangram Kesari Raut, my lord. Today I am appearing, my lord.
You have replaced whom?
Hon'Ble Senapati.
You are S.K. Sahu or Raut?
Raut, my lord.
This is which item, sir?
39, my lord.
13.
39.
39.
My lord.
Mr. Sangram Kesari Sahu,
Raut.
petitioner Mr. Sangram S.K. Raut, Sangram Kesari Raut, opposite party Mr. S.S. Mahapatra. Learned counsel for the petitioner submits that he has instructions to appear after the learned counsel who was appearing earlier has given consent for his engagement. Has given consent upon retiring from the brief. Name of Mr. S.K. Raut be indicated in the case brief as well as the cause list. Name of the learned counsel who were appearing earlier shall be deleted. Yes, what do you say? The order has not been complied with.
Yes, no, today I have prepared the affidavit, my
The
lord.
learned counsel for the petitioner seeks further accommodation to comply with the order dated 4/9/2023, though granted time earlier. How much time, by what date you will file the affidavit, sir?
Today I will file.
The affidavit be filed within 2 days. Copy be served on the learned counsel for the state to enable him to obtain instruction. List on 30th or you want December you want?
As you lordship.
When do you want as your lordship, please? ଆପଣ କହୁନାହାନ୍ତି ବୋଲି I have to expedite, I have to delete
Let
it.
it be come on 30th, my lord.
Yes, because he's saying that so almost 10 days you require.
No, I had the CD, my lord, but charge sheet required to be because since July CD was.
Yes. As spread for list on 30/11/2023. The learned counsel for the state shall also obtain up-to-date case diary. Yes.
Pardon, my lord, item 36. My lord, taken up 1 week after, my lord. 36 and non-appearance.
No, sir, non-appearance है नहीं. Call the next. Upon disturbed हुन्तु नहीं.
Item 40.
To be called again at 2 p.m. Next. 40 were there. Yes. 40.
I want an adjournment, lordship. Can we take it up next week? Petitioner.
Your name is you are appearing here.
Yes. A. Das.
Miss M.S. A. Das for the petitioner. The learned counsel for the petitioner seeks accommodation to comply with the order dated 8/9/2023
To file affidavit.
to file affidavit on behalf of the petitioner regarding indicating past allegations of criminal activity, if any. How much time?
1 week, Your Lordship.
As prayed for. List on 12th of December.
Oh,
Affidavit will be filed by 23rd November. Copy be served on the learned counsel for the state to enable him to obtain instruction.
12th December, Your Lordship.
Yes, you want it earlier.
No.
23rd, you have to file the affidavit,
Yes.
which you have been taking time. Yes.
41.
Lord, I am appealing for the informant, my lords.
Which was the petitioner, sir?
May I please your lordship? Offense on
You are Mr. Kedar Shankar Sahu.
my lord.
Yes, 41.
Offense under section 420, 468, 471 of IPC. Petitioner is in custody 24/7/2023. Allegation, my lord, and informant purchase.
What are the total number of cases pending? Details of
One.
other cases.
One.
How many affairs?
One. She has already released on bail, my lord. One antecedent is there.
You file that affidavit. File that affidavit.
Annexure
As
3.
per the practice procedure followed, the practice followed in this court,
Yes, ma'am.
the affidavit has to be filed on behalf of the petitioner.
Yes, ma'am.
Mr. M.S.Sahoo for the petitioner. Here, Mr. Mahapatra, you are there.
Yes, my lord. I
Mr.
am
S.S. Mahapatra, AC for the state.
My lord, here,
Mr. So, yes.
I may submit, my lord,
Yes.
here one criminal antecedent of police case and another two are complaint cases. My lord, total 3. My lord, he has to file affidavit with regard to the 3.
And same may be permitted to be withdrawn. Please file a memo. Have you filed a memo? Memo dated 13/11/2023, indicating the same is kept on record. After you file the memo, you will get the order. Please appreciate that. The petition is dismissed as withdrawn at this stage. Yes.
43.
Mr. Tukuna Kumar Mishra for
My
the
lord, I pray for next week,
petitioner.
my lord. Today I have received the charge sheet, my
Mr.
lord.
Vivekananda Bhuya, Special Counsel, State into bracket OPID. Mr. JP Patra also. Mr. JP Patra. Mr. Bhuya or Mr. Patra, whose name? Mr. Bhuya and Mr. JP Patra. ASC. The learned counsel for the petitioner submits that.
Today I have received the charge sheet, my lord. Copy of the charge sheet.
He has
Before
received copy of
I
the
have
charge
sent.
sheet and he may be accommodated further to advance arguments. As prayed for, list on. When do you want, sir?
Next week, my lord. Next week or any
List
other?
on today's 13th. On 23rd or 22nd? Who date कौन टूटे?
23rd.
23/11. Connected matter?
Same, my lord.
Same order.
Yes.
Yes. Connected matter, same order. Yes.
44.
Same appearance be same.
May I please,
Mr. Sanjeev Kumar Bhanjadev for the petitioner, Mr. S.S. Mahapatra, additional standing counsel for the
my
state.
lord, I am appealing for 44, my lord.
Yes.
44, my lord.
Yes, please.
My lord, here, my
You are
lord.
Mr. Bhanjadev, Sanjeev Kumar Bhanjadev.
Yes, my lord.
What's the mistake again I have done? But wrongly detecting or correctly?
No, correcting Sanjeev
The
Kumar.
whole
Bhattacharya.
problem is that in this kind of VC, when you start saying he doesn't understand, he gets confused. And at times the voice is also obviously it overlaps.
Yes.
So Sanjeev Kumar Bhanjadev for the petitioner, Mr. S.S. Mahapatra for the opposite party. Yes, you have filed affidavit.
Yes, my lord, I have filed. Your lordship has granted bail to the petitioner in one case.
Yes,
And in that case, your lordship has observed the petitioner has two other antecedent.
yes.
And in 1506 and other is
Se-
307. And here in this case,
Granted petitioner to one case means another FIR.
another affair.
Where is that order?
I have annexed
So
comprehensive.
that is there, but my lord, in this case, I require the case diary. Lordship kind have a glance to page 18. There is, my lord, in this case, he has fired at the injured, my lord, he sustained punctured injury, and also he was hospitalized. His condition required to be obtained, and also, my lord,
I have filed in the form of memo, my lord, deposition.
Along with the memo said to have been filed, the memo along with copies of the documents filed by on behalf of the petitioner shall be taken on record. Scanned copy be updated. Copy of the memo along with the annexer shall be served on the learned ASC to obtain instruction. How much time, Mr. Mahapatra?
my lord, week after, my lord. From
List on 22nd 11/2023.
My lord.
Yes.
I'll obtain the case diary along with the up-to-date
Yes,
case.
you also, what he says that trial has, because the,
Yes, my lord.
because what he says that in the other case, he has been released.
My lord.
So, and and he's in custody since 6 months. So after that order of 610 also, it is another 1 month, so 7 months.
Yes,
So that he is not saying.
yes, ma'am.
That I have marked.
And another thing, my lord, your lordship has also called for a report regarding injured.
But I'm sorry, my lord, urgent to who is it?
Keep date ହେଲା? 22nd. Yes, next.
45, my lord, on behalf of Mr. Panda, may kindly be adjourned.
Your name, madam?
Sonali Panda.
M.S. Sonali Panda on behalf of Gyanananda Panda, J. Panda for the petitioner, Mr. S.S. Mahapatra, ASC for the state, Learned Counsel for the petitioner, 6 accommodation to advance arguments, 6 further accommodation. As prayed for, list on 13 December. The Learned ASC submits that case diary is available.
Yes, sir.
Yes. Next, please.
46. May I please before your lordship?
Yes. Mr. Samarendra Mahanti for the petitioner, Mr. S.S. Mahapatra, ASC for the state.
My lord, custody since 1st August 2023. The case and counter.
The present health condition of the injured victim.
Yes, my lord, I received, my lord.
Yes, my lord.
He's okay. He mentions he's okay.
The criminal proclivity.
No, my lord.
No criminal.
And the case
12/10/2023. You have received the affidavit. 10/10 rather. As per your instruction in the case diary, he has any past allegations of criminal activity?
No, my lord.
Okay. Yes, Mr. Mahanti.
The case has been committed to the Court of Sessions, my lord. In the meantime, ST case number 298 of 23 has been registered and before the Learned Session Judge Jagatsinghpur. Case has been committed to the Court of Sessions. Case and counter case due to civil dispute between the brothers. The case and counter case has been registered between the parties. Co-accused person.
He has injured his brother.
My lord. Due to staircase construction. As per the
Assaulted by means of thenga and also lacerated wound on the head. Grievous injury.
The latest report is that he has recovered from the
His
injury.
health condition is okay, my lord. I am reading out.
On
Mr. Samarendra Mahanti for the petitioner, likely appearance. The Learned Counsel for the petitioner submits that the petitioner is in custody since
1st August 2020.
1/8/2023. Considering the nature of allegations and the fact that the alleged dispute that resulted in the incident is of civil nature, and the petitioner may be shown indulgence as far as the prayer for grant of bail is concerned. It is submitted that the petitioner has roots in the society. There is no likelihood of he escaping the jurisdiction of the learned court in season of the matter. And the petitioner shall abide by all terms and conditions that would be imposed for grant of bail. The learned Additional Standing Counsel, referring to the materials contained in the case diary and the nature of allegations, opposes the prayer for bail. Stop. However, it is not disputed that the injured victim, the injured informant, or what is he?
Injured.
The person injured in the alleged incidents has recovered and is in good health.
And also he's working as a driver. That has been mentioned in the
is in good health and has returned back to his avocation.
Yes, ma'am.
Stuff. Having heard learned counsel for the petitioner, the learned additional standing counsel, and considering the material on record as contained in the case diary, this court is inclined to grant bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also include a condition that, in case of any violation of oblique deviation from any of the terms and conditions, there shall be filing of petition for cancellation of bail by the investigating agency, oblique informant, oblique victim. Disposed of accordingly. Yes.
47 from Puri BC, may I plead your lordship? Due to my normal accident, I could not solve the copy. Another time may be granted to solve the copy.
Balakrishna Rai, for the petitioner, Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner, being present at the virtual court, Odisha High Court at Puri, addresses arguments. It is submitted by the learned counsel for the petitioner that he has not been able to comply with the order dated 6/10/2023, directing him to file extra copy of the petition on the in the registry of the court. As prayed for, list on. How much time, Mr. Rai?
1 week, man. 1 week.
As prayed for, further 1 week time is granted to comply with the order dated 6/10/2023. When the matter will come in December?
Yes, my lord. Any date.
List on 1/12/2023.
Oblige.
Yes, next.
48.
48 on behalf of
48,
Mr.
same order as
45.
45. Same appearance. Prayer also same, you want adjournment.
Yes.
Then date 48, 13 December. Yes, next.
49.
Yes.
Refer 1 week after.
Miss Bhaktilata Bola, MS. Bhaktilata space Bola, on behalf of Manoranjan Padhi for the petitioner. Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments as prayed for, list on 8/12/2023 to grant another opportunity to the petitioner, to grant further opportunity to the petitioner. Case diary has been received.
No, my lord, I am receiving today, my lord.
The learned AC shall obtain up-to-date case diary, public instruction in the matter. Yes, next.
Item 50.
May I please, Your Lordship?
Yes.
Case diary was called for.
Yes.
The present petitioner is in custody since, my lord.
Case diary has not been received, lordship. They are sending.
Mr. Sushanta Kumar Parala for the petitioner. Mr. Sorry. For the state, Mr. Bhukta is not the informant. The learned counsel for the petitioner submits that the petitioner is in custody since
28/7/2023.
28/7/2023. And he may be shown indulgence as far as the prayer for bail is concerned. The learned additional standing counsel seeks further accommodation to obtain the case diary as prayed for. List on how much time?
10 days, lordship. 30th October. September.
Yes.
51.
Item 51, I pray for not pressing. I'm filing a memo. Judgment has been delivered.
Judgment has been
delivered.
Date
That I have not instruction.
He has been convicted.
Yeah, acquitted as per.
So give the details. How much time you will take? Passover.
So I would say next week. Tomorrow.
Mr. Tukuna Kumar Mishra for the petitioner, Mr. Standing Counsel for the State, Learned Counsel for the petitioner submits that as per his instructions, the petitioner has been acquitted of the charges by the Learned Court in season of the matter, and he may be accommodated to give the details. As prayed for, list on 16?
Yes, ma'am. Okay.
List on 16, 11, 2023. Yes, next.
52.
Yes, sir. Sir, I am for petitioners from Puri.
I am also for the informer.
Sir, in this case, the two petitioners are women. One is mother-in-law and one is a pregnant sister-in-law.
CD is not there.
Charge sheet and CD.
CD is not there.
Not there.
Charge sheet already has been submitted, sir.
Yes, the State Council will obtain the case diary.
I have already. My information, they have already received the case diary. On that day, 8, 9.
Sir, that never happens.
There may be co-accused person in respect of co-accused person. Similar CD may have been.
This is, sir.
He doesn't understand.
No, already have submitted.
Sir, no one is saying that already has not been submitted.
Sure.
So you have to be patient, more patient than your clients, sir, while arguing a matter in these kind of cases.
Sir, she is a pregnant lady. Since 4 months, she is suffering inside the
What is the? I mean, the instruction is correct. She is in the family way. One of the accused.
Sir, kindly see the order.
One of the accused persons inside custody, or maybe one of the petitioners is in the family way. She is 4 months pregnant.
8 months, sir. 8 months. By the time of arrest, she was 3 months pregnant. It is available in the order.
What is the overt act attributed to that lady?
There is no overt act attributed to the petitioners. Only they have.
My lord, may kindly see the one statement they have, 161 statement they have annexed, my lord, page 19. My lord, the allegation against the petitioner are there, my lord. Kondare Akramana Kala is a 302 case, or 302, 307 is there.
May I please ask, my lord?
Sir, injury reports goes to show there is no sharp cutting injury, only by hard and blunt weapon by means of big bats. And they have supplied to their husband, and husband is the main assailant in this case.
34 is there.
May I please your lordship?
Is that, but sir, intention is that.
Yes, my lord. Mr. Panigrahi and Mr. Das, please appreciate what is happening in the court. Even if you are a VC, must understand the prosecution is saying they will obtain the case diary. So you have to be patient. Mr. A.K. Das for the petitioner, Mr. Standing Counsel for the State, Mr. Trilochan Panigrahi for the informant. The Learned Counsel, Mr. Das for the petitioner and Mr. Panigrahi for the informant, being present at the virtual court, Odisha High Court at Puri, address arguments. The Learned Counsel for the petitioner submits that who is the person, who is the petitioner, who is in the family way?
Petitioner number 1, sir.
The petitioner number 1 is in the family way. And she may be shown indulgence as far as prayer for bail is concerned. The Learned Standing Counsel shall obtain the up-to-date case diary, status of investigation. It is as it is stated by the Learned Counsel for the petitioner that the charge sheet, the FPR, final prosecution report, has already been filed on. So that's.
Sure.
That's sir.
No, sir.
26/9/2023. The health condition of the petitioner number 1 shall also be obtained through the concerned IO oblique jail authority. Yes. How much time, Mr. Standing Counsel?
10 days. Chandanpur 10 days.
As prayed for, list on 23rd or 24th?
24th, 23rd.
23rd 11/2023. Yes. 23rd 11, Mr. Das, Mr. Panigrai. Yes.
53.
Melod, I have affidavit filed with you.
Sorry. So kindly, madam, speak to the microphone. Yes.
I have already filed by the affidavit.
Okay. You are Miss Raut. You are M.S. Raut, Miss Raut.
Yes, Melod.
M.S. Chameli Raut for the petitioner. Mr. T.K. Prahara, Standing Counsel for the State, Learned Counsel for the petitioner, submits that as for the state, that the affidavit on behalf of the petitioner has been filed, indicating the past allegations of criminal activity against the petitioner. You have received copy and obtained instruction.
My lord, your lordship may see both the affidavits they have filed, my lord. Two affidavits they have filed. my lord.
Two have been filed. One is 17/10/2023.
Yes, another 18/10.
Yes.
My lord, nowhere, my lord, she has stated about the, my lord, cases, my lord. I'd have got the instruction, my lord. He has got another 302 case in his credit, my lord. But that has not been mentioned anywhere in both the affidavits.
Madam, could you follow what he's saying? What the Standing Counsel is saying? Could you follow it?
302, my lord, no, 498 case, my lord, 498 4 DP Act, my lord, family dispute case, my lord.
You verify corresponding to the case number or the PS case number, GR number, then you make your submission.
PS case
Otherwise, it becomes difficult for you to answer to his proposition.
Case number 1.
If you please read the brief before you come to the court. Spend some time.
No case number has been given, my lord.
My lord.
17/10 affidavit, your lordship may kindly see. Para 3, my lord, he was previously involved 498 case, he has stated. In which police station, but that doesn't, and he's released in criminal appeal. That means he has been convicted, my lord.
It reached, and again after resumption of the proceeding, once and again after resumption of the proceeding, upon resumption of the court proceeding after the lunch break, perusal of the available perusal of the records indicates that, or the order sheet indicates that the matter is pending since 2013. On all the occasions, starting with 18/11/2023, thereafter on 25/11/2023, 16/12/2023, 2/1/2014, 6/1/2014, so 2/1/2014 up to 2/1/2014, thank you, and 2/1/2014, the matter has been adjourned at the instance of the petitioner, Honorable Counsel for the petitioner. On 6/1/2014, none had appeared for the petitioner. Thereafter, 12/3/2014, the matter was again adjourned. Apparently, the petitioner is not interested in prosecuting the matter. To grant further opportunity, list on 28/11/2023. Mr. Devasis Naik AGA likhibe. Petitioner none, Mr. Devasis Naik AGA. Yes, next.
Item 10.
Item 10, my file misplaced, my lord.
Prasanna Kumar, Mr. S.K. Das for the petitioner. Mr. Opposite party blank, the learned counsel for the petitioner submits that he may be accommodated to retrieve his file, retrieve his case brief which has been misplaced. As paid for, list on, when do you want?
My lord, 2 weeks after.
Date Korantu? 4/12, 4th of December. Yes, next.
11.
My lord, 11 on behalf of Hon'Ble Ratna Panda, kindly take up this matter.
You are Mr. Das.
Satyajit Raut.
Mr. Satyajit Raut. Mr. S. Raut on behalf of Hon'Ble Ratna Panda for the petitioner. Prayer for accommodation is made on behalf of the learned counsel for the petitioner. The order dated 27/6/2023 indicates that the earlier order by the state order
that verification
was
report has
directed.
come.
Yes, the state was directed to verify the permanent address of the petitioner, permanent oblique present addresses of the petitioner as given in the petition. You have received instruction.
Miles, that address is correct.
Both the addresses are correct. One is from Nagaland.
Nagaland verification has come.
The learned AGA submits that from the police authority of the Nagaland of the state of Nagaland, a report has been received indicating that the petitioner's address, house number 228, jail, PS Kifire, district Kifire. He was in jail custody.
What is that? He's living with his brother. That's the statement given by the brother.
What is this jail?
Jail ward. The name of the place is jail ward. My house number 228, jail ward, Kifire town, Nagaland.
Well, that's very somewhat unusual.
Unusual matters.
Has been verified. Has been verified, and the said address is found to be correct. As far as the verification of the address given at Delhi, same is awaited. ତା ପୂର୍ବରୁ କଣ ଲେଖିଥିଲେ ଅର୍ଡରଟା କାହାର ସବମିଶନ ଟା କଣ ନୋଟ କରିଥିଲେ आज spread for तापर लिखो तो immediately तापर ले insert करंतु आज spread for list on when do you want 12 तापरे AGA को लिखिबे yes close the paragraph, close the order. Yes, next.
That's our item 13.
None appears for the petitioner, though the matter is called twice over. Once when it reached, and again after resumption of the proceeding, after the lunch break. And again upon resumption of the proceeding after the lunch break. Court proceeding after the lunch break. None had appeared for the petitioner when the matter was called on 9/10/2023. The learned court in session of the matter shall provide instruction as to whether the petitioner has surrendered after the period of interim bail granted by this court by order dated 13/6/2023 had expired. Registry to do the needful. List on 4/12/2023. Yes, next. So
this is sub item that will also be listed the same date. 13.
Yes.
Malad.
4th of 12. But who is appearing in the sub item? No one is present also. None appears petitioner none. Mr. Devasis Naik, AGA for the state. None appears for the petitioner, though the matter is called twice over. Once when it reached and passed over to be called again upon resumption of the court proceeding after the lunch break. Para. None had appeared when the matter was taken up on 1/11/2023. To grant further opportunity to the petitioner, list on 4/12/2023. The Lord AGSL obtained up-to-date instruction. In both the matters, Lord AGSL obtained up-to-date instruction, Mr. Naik.
Item 14.
May I please, your lords?
Yes.
Dear my lord, I have taken instruction from the learned trial court.
Yes.
That the present petitioner acquitted on my lord 11/9/2023.
11/9/2023. By the second additional sessions judge, Bhubaneswar, in T.R. number 19/261 of 2022. The appearance likely, Mr. R.C. Maharana. You are Mr. R.C. Maharana. Mr. R.C. Maharana for the petitioner, Mr. Devasis Naik, AGA for the state. Apparently, submission likely has been acquitted. The memo dated 13/11/2023 filed by the Learned Counsel for the petitioner is taken on record. The petition stands disposed of.
Okay.
15.
Same, first paragraph, same. None petitioner done. Mr. Devasis Naik appearance, Mr. Devasis Naik AGA. None appears for the petitioner, though the matter is called twice over. Once when it reached, thereafter being passed over after the lunch break upon resumption of the court proceeding. None had appeared when the matter was taken up on 9/10/2023. You have obtained the CD?
Not yet, my lords.
To grant further opportunity to the petitioner, list on 5/12/2023. The Lord AGSL obtained up-to-date instructions, case diary. Yes.
Item 16.
Including the statement of the victim recorded under section 164 of CRPC, along with medical examination report as directed by earlier order dated 24/4/2023. Yes, next.
Maybe.
Item 16.
Last occasion, my lord, direct to my lord friend.
You are
Of
Mr.
the instruction
You are
letter.
Mr. Lenka.
The action taken report, my lord, said called for.
SK Lenka
It received.
not received.
Not received.
Mr. SK Lenka for the petitioner, Mr. Devasis Naik, AG for the state. The learned additional the learned AG for the state seeks further accommodation to obtain instruction in terms of the earlier order dated 9/10/2023. As prayed for, list on 23rd, 11/2023. Yes.
Achha, item 21.
Next week.
Sorry, I forgot your name. Mr.
Satyajit Rao.
Mr. Satyajit Rao, Mr. S. Raut on behalf of A.R. Ponda for the petitioner. The learned counsel for the prayer for adjournment. Prayer for adjournment is made on behalf of the learned counsel for the petitioner. To grant further opportunity, list on 4/12/2023. Up to date case diary. Mr. Naik.
My lords, I have the case diary.
The learned AG submits that case diary is available. Yes.
22.
Petitioner none, Mr. Devasis Naik, AGA for the state. None appears for the petitioner when the matter is called, though none appears for the petitioner, though the matter is called twice over, once when it reached, and after being passed over, again after resumption of the court proceeding, after lunch break. Upon resumption of the court proceeding after the lunch break. Para, none had appeared when the matter was last taken up on 2/11/2023. When it was observed that as the matter has, no one is appearing for the petitioner, that is on 5/10/2023 and 28/8/2023, the petitioner is not interested to prosecute the matter. Para. In view of the above, the petition stands disposed of. Yes, next.
Item 25.
Item 25, Lords, on behalf of Dwivedi, prefer an adjournment.
Mr. S. Sota on behalf of S. Dwivedi for the petitioner. The learned prayer for adjournment. Prayer for adjournment is made on behalf of the learned counsel for the petitioner. As prayed for, list on 30/11/2023 to grant another opportunity to the petitioner. Grant further opportunity to the petitioner. Here case diary is available.
Malus.
The learned DGA submits that case diary is available. Yes, next please.
28.
Pray for adjournment on behalf of Mr. Madani.
You are Mr.
R. Behera.
Mr. R. Behera on behalf of Muhammad G. Madani, MD.G. Madani for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. Learned counsel for the anyone for the informant. Learned counsel for the petitioner. Prayer for adjournment is made on behalf of the learned counsel for the petitioner to grant further opportunity. List on 1/12/2023.
Case diary
The
164.
the learned AC submits that case diary along with statement of the victim recorded under section 164 of the CRPC is available.
Item 30.
During the offense number 307, along with other offenses, the petition number 1 and 2 arrested on 26/6/2023 At the petition number 3 and 4 arrested on 27/6/2023. So the FIR.
You should have filed separate petitions. What a gotte petition background olga, antecedent olga. Order ta kemti go. In fact, in one matter, after rejection of the first petitioner, second petitioner is pending for instruction. I don't understand how much one of the learned counsel gave a very brilliant answer that we are getting one wakalatnam.
All are brothers.
Sir, is that a relevant factor that if all are brothers, for past allegations of different criminal allegations, there will be one petition will be filed?
That is, my lord. My lord, there the affidavit paragraph 2, lordship kindly have a glance. The only PS case number and offences alleged, my lord, that has been mentioned. Nothing has been mentioned with regard to the status of neither the criminal case nor, my lord, the status of the petitioner in those cases. My lord, only mention regarding implication in the PS case number is not what is their conduct in those cases. My lord, that has to be filed. And in second bail application, the affidavit filed, my lord, they are having a criminal antecedent, but it has been mentioned that no criminal antecedents. For that, my lord, yes, they have to clarify and they have
now you understand what happened. What is the problem?
On second bail application, the petitioner have no criminal antecedent.
But the affidavit,
they are having criminal antecedent. My lord, my record shows they are having criminal antecedent. And also that is there, they may take note of this. Boliya Sasikanta, my lord, mentioned Sasikanta Behra is implicated under section, my lord, in Soro PS case number 4 dated.
Mahapatra, you are in both the cases?
Yes.
But chat kari hele diyantu?
Chat kari de diyantu.
Apangar confusion kam hoba, tankar kam hoba, at least I will be spared also.
That's my humble prayer. Next week asu. See what a tall court affidavit kari pathaychandi. Seithre कहले जे तांकर किछि केस नै. मु आउट क्लासिफाई करी detail.
That is understood. He could affidavit kale bhul kar dele, that's another thing. Ki thik kar dele seta out jinso. But apanakar jetebele gote competing mane comparative claims rahibo janakar kiछि accident nahi. Janakar accident achi. Janakar against 302 achi, another against 307 achi. So then the dictating order becomes almost really impossible because you don't get anything out of that affidavit. You prepare a chart where you indicate separately each of the petitioner. There are two applications. How many petitioners?
Here 4, another 2, 6.
No, 6 hochante accused. Petition, bail petition keteda?
Dita bail application.
Bail petition e 3 ta 6 ta.
Nahi, gote 4 gote 2.
4 2 apon kon divide kari karchanti. So se chatter apon separate kar diyantu tara Mr. Satyajit Mahapatra for the petitioner, Mr. S.S. Mahapatra AC for the state, Mr. S. Raut for informant. The learned counsel for the petitioner submits that he shall prepare a chart indicating the past allegations of the criminal activity, regarding which the affidavit has already been filed on behalf of the petitioners, plural. The affidavit has been served on the learned counsel for the additional standing counsel. In the first matter, there is some discrepancy.
Well, if
the learned additional standing counsel submits that there is some discrepancy regarding the statement made in the affidavit and as far as the actual number of cases pending against the petitioner.
And also with regard to the status of cases as well as petitioners.
The learned counsel for the petitioner submits that he shall also indicate the present status of all the cases, specifying the cases in the table that will be in the chart that will be furnished for perusal of this court, and you prepare separate chart at least.
Petitioner wise
or petitioner wise.
My lord.
Now you have to prepare 4 chart in the first and second petition 2 persons.
Yes, my lord.
At second same thing.
Same thing.
Second same order. But Mr. Subhankar Raut, you are not there in the second matter.
Your Lordship, I am not there in the second matter.
But it is one affair or the?
It's one affair, Your Lordship.
You are the only informant.
Your Lordship.
Then you have to be present there.
Your Lordship.
Also. That is another angularity of this. Yes. Mr. S. Raut for the informant. Multiple affair maybe, but since there is only one affair out of that incident, single incident, so you have to be noted there. Your presence have to be marked. Yes. or you are not opposing Sasikanta Balia's?
No, Your Lordship, I am opposing.
That is very strange. Acha, you are opposing.
Your Lordship.
Yes. Then he has got buy one get one. Yes. Next.
Mr.
Mahapatra, when do you want? 24 karo.
Next week asu 21 asu
21. But upon prepare kar diontu ago.
I will file it.
At least you upon jodi dionte jaldi so that I can ask them to obtain instruction.
ମୁଁ ତା ପୂର୍ବରୁ ଦେଇଦେବି. Friday I will submit.
A list on 24 the chart indicating the memo containing a chart indicating the allegations of criminal activity against the petitioner be filed by 16.
Yes, ma'am.
By 16. Copy be served.
Yes.
Yes.
Item 32. 32 may please.
Yes.
On behalf of Mr. S.K. Lenka, my lord.
Yes.
As for your lordship, last occasion directed to file the affidavit to special counsel, my lord, to FID, and they filed the affidavit. The IO filed the affidavit regarding implication, financial implication of the petitioner, my lord.
Yes.
The company has transferred to the petitioner's account joint account, my lord. Rupees 19 lakh.
Now when you are submitting, sir, you are referring to the affidavit by the
yes.
I mean the investigating agency or your affidavit?
No, the investigation agency filed affidavit.
I understand.
Yes.
But you have filed an affidavit?
Yes, I will take over. So.
Oh, you want to take instruction on that?
Yes, ma'am.
Mr. K.C. Behera for the on behalf of Mr. S.K. Lenka for the petitioner. The Learned Counsel for the petitioner submits that he has received copy of the affidavit filed by the Additional Superintendent of Police, Economic Offences Wing, CIDCB, Bhubaneswar. And he seeks further accommodation to obtain up-to-date instructions in response to the same and file affidavit on behalf of the petitioner if so advised. Here, how many petitioners are there, Mr.
One petitioner is the bail application.
Santosh Kumar Ratha?
Yes, ma'am. The connected matter, my lord.
Yes.
BLPL number 8100.
Yes.
The MD of the set is company, man. The posted to
connected in the sense the 8100 8729. There are two matters. First matter, both are by the same petitioner.
8100 is the MD of the said company.
Oh, that has not come.
Yes, my lord. It is interim bail, my lord. Your lordship granted interim bail the petitioners in this case, my lord, and posted to on this.
This is 32.
It's 32.
No, that record has not come.
Yes, ma'am.
The scanned copy of the BLAPL number 810023 be also prepared for perusal for reference by this court. So that is an assignment or that has already been bail has been granted.
No, my lord. The
interim bail has been granted.
Your lordship granted interim bail.
Here, what has happened? Has he got interim bail or he has not got interim bail?
No, my lord.
Because they are saying that if granted interim bail, they can do something.
I don't know anything.
Okay, you obtain instruction. You have already said that you obtain instruction. Before that, give a date. Which date चाहुंचंती आपण?
Next week in that.
As spread for list on 23rd or 28th.
23rd, man.
23rd 11 2023. So Patra, usually they are depositing to what extent? I mean, there is no hard and fast rule because it's a criminal proceeding.
Usually, my lord, the amount mentioned in the charge sheet, my lord,
Yes.
that they are depositing.
In the court,
In the trial, yes, my lord.
in the trial court.
My lord. Here, my lord, amount mentioned 8 crore something, my lord.
In paragraph 9, you were saying 14 lakhs.
No, for 19 lakhs, my lord, that amount directly transferred to the amount of the present petitioner from the company account, my lord.
Para 7, 8 crore 21 lakhs.
My lord.
Okay.
That is the total amount.
Item 36.
On behalf of Mr. M.S.Sahoo, my lord, may kindly be taken up second week of December.
Sir, your name, sir?
HK Das.
Naata kuntu.
HK Das.
On the power of HK Das on behalf of the petitioner. Mr. S.S. Mahapatra, AAC for the state. Learned counsel for the petitioner seeks accommodation to advance arguments as spread for list on 6/12/2023. Case diary is available.
No, my lord, case diary has not been received.
The learned AAC shall obtain up-to-date case diary, oblique instructions, oblique stage of trial. Yes, next.
37.
May I please, my lords?
Yes.
Lords, your lordships have directed the state to obtain the charge sheet. There is one criminal antecedent. To that effect, I'll file an affidavit. I'd already submitted in my petition.
You are Mr. Das.
My lords.
Mr. P. Das for the petitioner, Mr. S.S. Mahapatra, additional standing counsel for the state. Learned counsel for the petitioner submits that he will file an affidavit on behalf of the petitioner, indicating the past allegations of criminal activity, if any. The affidavit will be filed by how much time, sir?
It's 1 week.
Affidavit will be filed by 21/11/2023. Copy be served on the learned counsel for the state to enable him to obtain instruction. List on 1/12/2023.
It's
you have received copy of the final police prosecution report.
Yes, my lord.
The learned additional standing counsel AAC submits that the copy of the final
my lord,
FPR has been
sorry,
received.
my lord, CD received. Is final PR not received? I will be.
The learned AAC submits that case diary has been case diary has been received. Stop. He shall also obtain up-to-date instructions in the matter and whether the final prosecution report has been filed or not. And instruction whether FPR has been filed or not.
Pardon, my lords, if it would be on 24th of November or any, since your lordships are fixing.
How does it help you, sir?
Any
How
day
does it
now.
help you 24th?
I'll file by week, my lords. Your lordships are fixed for 21st.
Yes.
By
So after filing, I will grant bail.
No, my lords. Lordship,
Without considering that.
Lordship, please.
Sir, you are taking time. When did you file the petition?
The petition was filed
on 7/8. You are filing a petition. Exactly after 3 months, you are saying you will file affidavit.
It's since the lordships had undertaken the practices to file an affidavit, therefore the reason else I'm seeking your lordship's indulgence to file an affidavit.
This practice was not there on 7th of August.
No, my lords.
It was not there.
No, my lords. I bow
Please
down.
appreciate that.
I bow down, my lords.
Please appreciate that.
I'm not submitting like that.
You are when you are. I mean.
I bow down, my lords. I'm not making such submission, my lords.
You are not making. But the problem is that you are saying as if you file on 21st, so it is urgent for a long date.
No, my lords.
But you have adjourned it for exactly 3 months.
No, my lords.
In every matter. Every matter, the petitioner counsel is adjourning. Finally, the date the affidavit is filed, it may be considered. Then what is the point in filing the petition?
Lordship is fixed too.
Then why there is a High Court rule that the petition is to be served on the London State Council? Only to facilitate your case. So that they will obtain instruction.
My lords.
And if the petitioner is not, fair enough to state truth before the lawyer like you, then what is the point?
Well,
he should have filed that affidavit on the first date that I have so many antecedents. What is the status of the case?
Well, it's just a small submission.
The petitioner submission जोड़े record करछे. Past allegations also along with the details of the present status of the cases, comma, if any. Yes, what you were saying?
I'm sorry, my lords, I'm lifting your lordship's mail. It's actually I had filed the affidavit, not an affidavit, my lords, I had submitted at page 10 of my bail application the details of the criminal antecedent. So my lords, I'll just I had made my lords a fair.
You filed a one-line affidavit.
I'll do that.
File a one-line affidavit that I have already filed the details in the bail petition. That
My
you can do.
My lords,
Lawyer is never out of.
I'll do that, my lords.
You are not at your wit's end that what you will do.
No, my
Court will not to assist you.
My lords.
And in many cases, like you have seen Mr. Mahapatra's matter,
My lords.
there are 6 applicants in whose affidavit, whose antecedent is mentioned, he is not also sure.
I'll do. Deeply.
And by simply mentioning the case, it doesn't help. What is the status of the present matter, whether you have been granted bail or not, whether you have misutilized the liberty.
That will be.
That is not
And in case of NDPS?
I'm sorry, my lord. That
Yes.
is not an affidavit. What my lord friend is submitting, page 10, that is
that
the
was-
part of the case diary which
That
has
was
been
the part
submitted
of
by
the memo of arrest, man. You just served on me. So,
that is
that
not.
I've
We-
given it fairly months in my petition. So
I am also very fairly stated,
I
and
understand.
he is
I bow down to your lordship.
he is so brightly fair that he is saying that it is part of the FPR. You state on record, state on oath on behalf that how many cases are pending.
My lords, my
ଆପଣ ସେ ତା ସାଙ୍ଗରେ କଣ ସମ୍ପର୍କ ଅଛି ସେ ତାର ଇଏର?
I'll do that.
And status of the present criminal.
Because that is not filed by you. You are filed a copy of the this FIR
Memo
of
of arrest. Prosecution report. my lord.
prosecution report. That's a copy of the prosecution report.
He has to submit.
Then they have filed.
What is their status? my lord?
Yes.
He has to clarify in the affidavit.
I'll clarify that.
Yes.
Oh, bless.
Item 54.
Date କରିଛନ୍ତି ଏଇଟା last matter ରେ date କଲେ affidavit filed by
23rd, your lordship.
ଆପଣ affidavit କେବେ ସୁଦ୍ଧା ଦେଇପାରିବେ କହୁନାହାନ୍ତି 17 ସୁଦ୍ଧା ଦେବେ
17 ସୁଦ୍ଧା ଦେଇଦେବି।
affidavit filed by 17 copy be served list on 28/11 yes
Deeply blessed.
My lord, another 4x may kindly be given, my lord. We are not able to get the correct address.
54 past over गुड़ा सब call कर देले 54 Mr. Standing Counsel for the petitioner Mr. Opposite party blank. Office note put up by the registry indicates that the steps for issuance of limitation fresh notice on limitation to opposite parties 1 and 2 in the present correct address has not been taken. The learned Standing Counsel submits that despite their efforts, despite the efforts of the petitioners, they have not been able to get the present correct address of the opposite parties, and for the time may be granted to do the needful. Prayer is allowed for the 4 weeks time granted to take steps for obtaining the present correct address of the opposite parties and file requisites for issuance of notice by registered post with AD. Yes.
55.
My lord, 4x may kindly be granted for taking.
Mr. Standing Counsel for the petitioner, opposite party blank. The office note dated so and so. Always mention the date. Office note dated so and so indicates that the notice issued to the opposite party number 4 has been returned unserved with a note by the postal department, quote, incomplete / insufficient address. Stop. Quote ends. Full stop. Para, the learned Standing Counsel seeks leave to take notice afresh to the opposite party number 4 in the present correct address. Prayer is allowed. Let steps be taken for issuance of notice to opposite party number 4 by registered post with AD in the present correct address. Within 4 weeks. Requisites to be filed within 4 weeks. 4 weeks. List after SR. Office note dated 28/2/2018. Reiterated on 8/11/2023. List after SR ta purbo lekhantu unutilized copies of requisites, comma, if any, shall be utilized. Yes, next.
56.
MC lekhantu 12/2008. The petition has been filed for the continuation of delay of 52 days in filing the petition. Hard learned standing counsel for the petitioner. State issue notice.
Well, requisites were filed, madam. 17/1/11, well, requisites were filed.
Then why it has come as like that?
Issuance of notice.
Cutting lekhantu.
I'll take a press.
Office note put up by the registry. This is CRLLP 132/2007.
My lord.
Yes.
My lord, detached to 71 requires filed. My lord, may kindly
submits that we are saying 17/1 it was filed.
My lord. 13, my lord, 13/11 it was directed. 13/1, sorry, 13/1 it was directed for filing of notice to open number 2 to 4, and we have filed it on 17/1.
Here the petition opposite party counsel has appeared. This is one. This is serial number 56.
Yes, my lord.
Opposite party none. This case. None appears for the opposite party when the matter is called. To grant further opportunity, list on to the opposite party. List on 8/12/2023. Can you serve an extra copy?
My lord.
On the learned counsel, Mr. R.K. Sahoo. The learned standing counsel shall serve an extra copy of the petition of the IA, Miss case likhive, on Mr. Rabindra Kumar Sahu for the petitioner. phone number ଦେଇ ପାରିବେ ନା ସେତେବେଳେ rule ରେ ନଥିଲା phone number? Yes.
ନଥିଲା.
Yes, next.
57.
Mr. Standing counsel for the state.
Same.
Opposite party none.
They have appeared.
The petition has been filed for condonation of delay in filing. The application has been filed for condonation of delay in filing the petition. That is delay of 200, how much? 95 days. Appears for the opposite parties. To respond to the petition of the prayer of the petitioner for condonation of delay, to grant further opportunity, list on 7/12/2023. Yes, next.
58.
Please, Your Lordship.
Yes, please.
Your Lordship, turn to the application at flag A, my lords.
Yes, please.
Flag A is an application for condonation delay because we have already filed that requisites, my lords. Now, the application, my lords, when
you are appearing.
Yes, my lord. I am appearing for the.
Yes, Your Lordship may kindly permit me.
Yes.
That application, if Lordship can peruse, only contains 4 paragraphs containing 9 to 10 lines, my lords.
Yes.
And if Lordship permit me, Lords, for condonation of delay of 260 days, no reason, no causal reasons have been ascribed to describe the circumstances for which the petitioner was not could not file the application in time, Lords. There is no cause and reason ascribed, Lords. Now, if Lordship turn to page 4, Lords, because the meritorious case cannot be thrown out at the threshold, Lordship turn to page 4, Lords.
Yes.
Page 4 of the petition, Lords.
Yes.
If Lordship can turn to the ground number 3. I'm placing the first line. The learned trial court has lost sight of the fact that though the decoy and the overing witness has turned hostile, didn't support the prosecution case. If Lordship can take a post, Lords, in the entire Prevention of Corruption Act matters, Lords. All those matters can be categorized in 4 categories. 1, disproportionate case. 2, misappropriation. 3, special court matters. The 4 is trap case. This case at hand pertains to the trap case. And in a trap case, there are 2 eyewitnesses. When the tented money was given to the person who demanded that that bribe amounts, that is to be given by the decoy, the complainant. In other words, this synonyms of decoy is the complainant, the informants. And the overing witness, a person who accompanied to see the process of giving, demanding, giving, and giving signals to the other trap party members who are around to rush. So these 2 witnesses are the eyewitnesses in the trap cases. Both have their results and didn't support the prosecution case. This is the merit of the case. Lords, I leave to a Lordship, Lords, to dispose of the application along with the CRLP, because the application was filed in 2012.
Copy of the judgment?
Copy of the judgment, Lords, is dated 22/10/2009.
It is not annexed. 21/2 is no.
There is delay of 743 days, my lord. Your Lordship, kindly see.
Listen to me.
No, he has already placed it. I marked that 743, but I am not unable to get the copy of the judgment.
That is there, Lords. In that judgment dated, if a Lordship permits, then I will give the judgment also. That judgment dated 22nd October 2009, because the SR was there and SR indicated requisites are not filed. That has been filed. Now the case is for disposal of the application.
Your petition is page marked.
Beg pardon?
Your petition is page marked. Can you suggest the page where it is found?
Yeah, it's 9 plots.
Page 9.
Input order starting from page 9. Did you get?
आइए लिखन्तु मिस केस 39 of 2014, CRLLP 18 of 2012. This case has been filed for condonation of delay of 743 days in filing the petition. Though the cause title of the petition shows that the petition is for condonation of delay of 765 days, the petition at paragraph 1 indicates that there is a delay of 260 days. Wherein it has been stated that, wherein it has been stated at paragraph 2 that for the apparent reason that the file has to be routed through different departments, the delay was caused. That is Postmaster General. That
Postmaster General, correct. That's the leading judgments.
As per the decision rendered by the Honorable Supreme Court.
Under what circumstances the petition was prevented by sufficient cause in not filing application time has not been specified.
Can you give the citation of Postmaster General? Okay, I'll get.
I'll get out the judgments. In my note copy is there. Permits me, I will supply the citation in course.
If I remember correctly, it may be available. In Postmaster General, so and so. Versus Living Media into bracket 2012 bracket closed 3 SCC 563 and in Chennai Metropolitan colon into bracket 2014 bracket closed 4 SCC 108. It has been held by the Honorable Supreme Court that the what you are saying submitting
that there is no causal reason ascribed.
That when no causal reason is ascribed,
under what circumstances the petitioner is prevented?
The petitioner, under what circumstances the petitioner was prevented in filing the petition
within the stipulated periods, except horizontal and vertical movements of file in the inter-department.
The delay should not be condoned. Further, in several decisions, including the above two decisions, it has been indicated that it has been held that file being routed through different departments at different levels at different stages is not a good ground to condone the delay. Further, presumably under the impression that there is a delay of 260 days, 515 days delay has not been explained, as the total period of delay is 765 days. The right accrued in favor of the petitioner after the acquittal cannot be interfered with by entertaining a petition amounting to the delay of 765 days. Para. Apart from the above, this court has the occasion to go through the impugned judgment as has been annexed to the petition. Wherein the learned court has dealt in detail with the prosecution witnesses presented by the prosecution to prove their case. The learned court has taken note of PW7, who is the decoy in handing over the bribe money to the accused. The PW7's witness evidence, PW7 statement has not supported the prosecution case. That has been dealt at paragraphs 5 and 6 of the judgment. The other vital witness presented by the prosecution, that is PW,
The shadow witness, the accompanying witness.
She's 1 or 4?
1. It is yeah.
Sentence second. 1 and 4.
1 and I think it's 1.
4 also.
But 4 was also the
remain along with the informant over here. He's the overhearing witness.
Yes.
PW 1 and 4 have also not supported the case. The statement of the PW 1 and 4 has not supported the prosecution case. In view of the above, in considered opinion of this court, apart from the delay having not been explained in filing the petition, otherwise on the merits of the case, the petitioners have not made out a case for grant of leave. Accordingly, the petition stands dismissed.
Consequently, CRLP also.
Both have dictated one order. The petition seeking leave has been dismissed along with the MP.
May I submit another thing?
Yes.
Lordship may delete PW1, PW4.
PW4 can record. So you one compound order in both.
I'm reading that one. I was asked to accompany the informant, and
yes, that I was pointing out.
1 and
overhearing
1, 4.
4.
Correct.
So I'm passing one order in this case along with the LP. Yes. So mention both the numbers. Yes.
the miscase is disposed of. Consequently, the
In this case, prayer rejected, LP is also rejected on both merits as well as on limitation ground. And in limitation, somehow 500 days is not been explained. 260 days.
That's a cause and reason.
Yes. Mr. Ashok Das for the opposite party. You are Mr. Das. Mr. Ashok Das for the opposite party.
59.
Lord, in this case also the state vigilance has referred this petition, and this petition is at your lordship flag A, my lords.
Yes.
Here, my lord, the delay calculated by the department is 313 days. In order to turn to flag A, my lord, that's a miscase. Here also, unfortunately, when it was filed in 2014, no reasons whatsoever, my lords, has been ascribed describing the circumstances for which the petition was prevented to file the appeal in time. Absolutely nothing. Now, with regard to the other point that meritorious case should not be disposed of at the threshold, let's turn to the page 2 of the petition. Page 2 of the petition.
Yes.
Paragraph 2A notes.
Yes.
The background says the accused was Dhruvo Naik, was the BDO in charge. He, along with that store in charge, my lords, they have purchased fabricated iron doors and windows at an inflated rate, my lords, of rupees 1,56,614. Of the incident happened to 998, my lords. My lords, I also examined. No, there is no unimpeachable evidence on records, my lord, to substantiate, my lords, even this.
Mr. CRL, here the miscase is 32 of 2014.
The registry has indicated
along with 301 days. Along with CRLLP 20 of 2011.
2012, my lord.
12. It's a mistake.
Lekha is 2012.
Should I say a typographical mistake? CLP 20 of 2012. This case has been filed for condonation of delay of.
I'm disturbing, lords.
I'm so sorry.
Item number 59. Are you appearing there?
Opposite party, my lord, 3.
Lords, you can see the noting on the list.
Opposite party number 3, I am appearing, my lord. Noting re achi 1 OP number 1
expired.
I'm appearing for OP number 3 only.
The miscase has been filed for condonation of delay of 301 days in filing the petition seeking leave. The petition has been filed seeking leave under so and so provision likhive, challenging the order dated 6/8. The order dated
30/08/2011.
31 or 21?
No.
25 January.
21st January
2011. 21st January 2011, passed by the so and so. Likhive. On perusal of the petition, the reason indicated in the petition is that the file had to be routed through different department of the state, which requires considerable time to take final decision. State, for which requires considerable time to take final decision by different departments. As per the law laid down by this court, by the Supreme Court in 2000 into bracket 2012 bracket close 3 SCC 563, Postmaster General versus Living Media, and into bracket 2014 4 SCC 108 Chennai Metropolitan. पूरा citation टा पर देखिए बाहर पे लिखिए. Such explanation of pushing the file through different departments causing the apparent delay, causing the delay, is no good ground to condone the delay when the statutory period of limitation is prescribed and a valuable right accrues in favor of the person against whom the petition is filed. Para. Since no cogent reason has been shown to condone the delay, this court is not inclined to condone the delay of 301 days in filing the petition. Para. Apart from, then write CRLLP 20th to 12. Apart from the reasons indicated in not condoning the delay as above, this court has occasion to go through the judgment passed by the learned trial court.
Your Lordship, turn to page 17, my lords.
As enclosed to the petition filed by the petitioner,
The reason at the running page 11, then my lords, that is the reason is one line evidence.
Para, the learned court has discussed the evidence presented by the prosecution in detail.
That reveals as a video call for quotation.
The learned court has given a categorical finding as contained in page 9 of the judgment that PW10 has stated that he had not made any physical verification weighment of iron doors and windows. He cannot say the total weight of 125 doors and 125 windows. Yes. And for the evidence of PW7,
the exact finding has to page 11.
PW7 has stated what? Because since the depositions are not a little bit difficult, but we can infer from the judgment.
Ultimately, the entire controversy revolves around that.
You see, there is no physical verification.
He has purchased all this thing at an inflated rate, but he resorted to a quoting system, that tender system. Let's turn to.
No, that is the allegation. That is the allegation that though
that was
he purchased it, but as inflated rate. But without physical verification, how it can be known?
That is one of the points how it raises eyebrows. That is lots of correct notes. Another findings for which the
suppose Mr. Das, suppose you allege that he has inflated it. Is it that you will not verify it?
Correct, Lord. That raises eyebrows. Your Lordship, correct. And the exact finding is at page 11. Hence, the prosecution is failed. What is the reasons? Rather, from the purchase file, it is revealed that BDO called for the quotation of different parties, and the office prepared a comparative statement. In charge, the BDO placed orders to firm whose rates were the lowest and received the material as specification.
That indicates how the PW7 that is not very clear. That is not very evidence of PW7. That is not very clear as to how PW7 weighed 122 number of iron door frames and 124 number of iron window frames and prepared a weighment chart that was produced as part of the prosecution evidence. Could doubt weighment chart that was produced as part of the evidence of the petitioner by the prosecution, not here. The prosecution is petitioner. Even the evidence of PW7 did not clarify that, in fact, the doors and windows were supplied by Utkala Ispat Udyog as alleged. In view of such categorical finding given by the learned court of the first instance, the learned trial court, on merits also, the petitioners do not have a case to grant leave to appeal. Para. In view of the above discussions, the miscase filed for contention of delay is dismissed, being devoid of merit, along with the CRLLP. Yes. Obligement. Mr. Polida, you have filed power here.
Yes, Your Lordship.
Mr. G.N. Polida for the opposite party number
3.
3. Gote ta purbu lekhibe. It abates against the OP1.
Yes, Lordship indicate.
First opening line, opening paragraph lekhibe, the
in view of the notings of the
in view of the noting put up by the registry, the notes put up by the registry dated 9/11/2023, indicating that service return of the notice issued to OP number 1, return unserved with a postal endorsement, addressee expired. Quote likhibe, addressee, quote begins, addressee expired, hence return to sender. Quote ends. The petition, the miscase, that's the notice in the IA. The miscase abates against the OP number 1. GN पर OP number 3 पे रख लिखले ना appearance अपना OP 2 पे appear करना है
नहीं सर वो खाली OP
ठीक है yes
item 60
obligement.
Yes, pleasure, Lordship. This is in a case of trap, Lords. The accused was let off, and challenging that orders the or acquittal, Lords.
Yes.
State Vigilance has preferred this petition and filed an application for condonation of delay, Lords. Delay in this case, Lords, is around 350 days. If a Lordship turn to the miscase preferred by the petitioner, it indicates 350 days delay, Lords. And as usual, my lord, it was filed in 2014. I don't pray for.
But apart from that line, after that was rejected by the Supreme Court, that pushing of file, it should not have been taken, mentioned in so many words. I don't know.
Lords, I could not follow, my lords.
After that,
post office, ma general.
Prior to that also,
yes,
that movement of file is not a good reason.
Yes, my lord. Movement of horizontal and vertical movements of file in the guise of consultative processes, my lord, cannot be a cause and reasons to condone the delay.
Now, as you know, you and me were at receiving end before the so many courts for this thing. As far as condonation of delay is concerned.
But at the same time, one line was there in that judgment of Jammu Kashmir that the meritorious case, however the delay may be, cannot be thrown out at the threshold. That's why, my lord,
But when you take a definite stand that file was pushed, that should have been avoided actually. You see, judgment rendered by the learned trial court.
Lord, turn to, for 1 second, Lord, turn to page 5 of the petition, the ground number 3.
Yes.
Did your lordship get that exact line, Lords? Page 5 of the petition, ground number 3.
Yes, ground number 3.
For that, the London trial court has lost sight of the fact that though the overwhelming witness has turned hostile, didn't support the prosecution. The prosecution has proved the demand and acceptance finds corroboration evidence of the complaint. But only complainant, my lord, the interested witness, my lord. The purpose of sending an overwhelming witness or the shadow witness is to see the act of demand or the factum of demands, and to see that this transacted given
that paragraph, the last line, the last but one line, kindly see. The accused has demanded and accepted the bribe. Actually, the acceptance of bribe has not been proved.
Correct.
But in one case, that's a
suppose I throw
service matter. Is it the case that if it is demanded, then it is criminality also arises?
Demand, accept, both the factors has to be proved.
Exactly.
Otherwise, suppose I throw something.
Because in that case,
if it is recovered, unless you prove the acceptance.
Yes. That was a division bench matter. it's a railway matter. So it is a case of CBI. After investigation, they furnished the report to. They said that it's not a fit case. It's not a fit case for prosecution, but departmental proceeding can be initiated. Departmental proceeding is initiated. Then what happens? The departmental proceeding, a finding is given that yes, the factum of acceptance of the demand of this bribe is not proved. But still, then they impose a punishment.
Punishment maybe a minor punishment or
it's a major punishment.
Maybe a caution.
That order was set aside by the division bench. Here,
this is morally not possible.
Yes, it has been fairly stated in the petition filed by on behalf of the petitioner state that the overhearing witness did not support the case of the prosecution as far as acceptance of the bribe is concerned, bribe money is concerned.
The overhearing witness PW2.
PW2, into bracket PW2. Para. Perusal of the judgment indicates that the learned court has dealt in detail the evidence presented by the prosecution. The official witness into bracket overhearing, that is PW2 and the PW3.
PW2, para 9, next page.
PW3, stop. While discussing the evidence of the PW2, the learned court has given a finding that PW2 did not give PW2 did not support the case of the prosecution.
And in his cross-examination by defense, the complainant gave something to the accused by having brought out from his pocket, but he cannot say what he gave to the accused. It didn't support the prosecution case.
Prosecution case. Para. In view of the above, it is indicated that the person who is supposed to be the eyewitness, being an official witness, has not supported the prosecution case. Para. The petitioner have not made out any case for interference in the merits of the case. The miscase for condemnation of delay is rejected. There being no satisfactory reasons stated in the petition. Also, there is no case made out for grant of leave to appeal. And the CRLLP is also dismissed. Yes, next.
61. 61, Lord, the noting is that
you have to take fresh steps. Mr. Sangram Das, Senior Standing Counsel for the State. It is miscase 34 of 2014. In terms of the earlier order dated 21/2/2019, requisites were filed for issuance of notice on the question of limitation.
The rest has indicated 476 days.
The office note put up by the registry dated 9/11/2023 indicates that the notice on limitation issued to the sole opposite party returned unserved with a postal report stating, quote, addressee is unknown, hence return to the sender, quote ends.
The Learned Standing Council seeks leave to take notice afresh to the opposite party
by ascertaining the fresh address.
in the present correct address. Prayer is allowed.
3
Let
weeks
notice
time.
be issued to the sole opposite party in his present correct address by registered post with AD.
3
Request
weeks
be filed within 4 weeks.
Ascertain the new name. Since we have to ascertain the fresh address.
4 weeks. 4 weeks I'm granted.
Developed.
Request be filed 4 weeks. List after SR.
62.
Delay has been condoned, Mr. Standing Council.
My lord, no, my lord. They have appeared. Notice has made some
268 days delay.
Yes, my lord.
Here the same problem, Mr. Standing Council.
My lord, but
After the opinion of the public prosecutor 11/6/2011,
yes, my lord.
the government grants permission to file CRLLP
Yes, my lord.
in
But in
February
that-
2012.
Yes, my lord. In that regard, my lord, we have come across a new decision, my lord. My lord, that is the October decision, my lord, where, my lord, all the decisions relating to has been reported, my lord. And that is the decision recently, and there are, my lord, it's a land action appeal, 400
Land
something.
acquisition is different.
My lord, that in that
You see,
appeal, my
land
lord-
acquisition appeal regarding the award or what?
yes, my lord, land action appeal. Yes.
So what was the consideration? That he's a oustee or not? His name is included in the 4-1 notification or
My lord,
not?
in that,
Suppose. Now, so why I'm just discussing. I'm just discussing. Suppose X is there. He's not a oustee. Yeah, award has been passed. Then it will be lost to the public exchequer. And that decision is already there since long.
in that context, it has not been passed. Taking into
Then
all-
what is the reason?
in that
Then if it is oustee, you don't challenge, then there is no decision by the Supreme Court.
my lord, in this present,
Quantum, suppose even quantum alleged in another case
my lord,
of same
Yes.
description, same area.
yes,
Then the delay is condoned.
yes,
High Court is condoning, Supreme Court is condoning.
my lord, here, my lord, in not in that context, my lord. In my lord, taking into all things, my lord, aspect, my lord, need to consider this is a big judgment. My lord, all the judgments that are, my lord, has been taken care of, and the Honorable Apex Court has, my lord, on the para 37, my lord, I am just placing, having bestowed upon the serious consideration of the rival contentions, we feel that the High Court decision to condone the delay on account of first as well inability to present the appeal within time for the regions assigned therein doesn't suffer any warranting interference. As the aforesaid judgment has been shown, an exercise of discretion does at times call for a liberal and justice-oriented approach by the courts, where certain leeway can be provided to the state. The hidden forces that are at work in preventing an appeal by the state being presented within the prescribed period of limitation so as not to allow higher court to pronounce upon legality and validity of an order of a lower court, thereby secure unholy gains, can hardly be ignored. impediments in the working of grand scheme of government functions have to be removed by taking pragmatic view on balancing of the competing interest, my lord. For the aforesaid foregoing reasons, the special.
So unholy nexus that I was telling you.
Yes, my lord.
X is never entitled. You see, Mr. Standing Counsel, the same thing has happened. So sitting in division bench, all those matters of land acquisition.
Yes, my lord.
The division bench directed for inquiry. And in one matter, it was found that the report was prepared in favor of a person who is not entitled. The officer was, because of that order, the officer was also proceeded against. So there is a possibility in land acquisition matter. If we are bringing this, Chengalvarya Naidu, that is there, if this Lord Dening's quote, famous quote, fraud unravels everything. So there is an unholy nexus, you are committing fraud, you are trying to get the compensation,
yes,
and ultimately there is a delay of 700 days or 900 days.
There.
So that judgment is also followed in the similar in Justice Pasay's judgment from Odisha.
That thing has
that land matter. Bhubaneswar land matter, the order passed by this member board of revenue was upheld. I think Bisoi. The title is Bisoi or something.
Yes, yes.
So here what is happening? Here you are simply in two lines saying that it went to so and so, and it takes lot of time.
Yes.
How can it take lot of time?
Each day of delay has to be properly, my lord.
Yes. So decision making, for coming to High Court, even it takes a lot of time.
Correct. It has to be properly explained. Each day of delay.
No, here what you are citing, that is a decision where it was condoned or not condoned.
Yes, condoned.
It was condoned. There is a possibility that, like granting aid matters, there is unholy nexus. It was deliberately delayed, and then thereafter, after the education tribunal, every matter got stuck.
Yes.
Yes, what is the merits of the case? You come to that.
Regarding merit, my lord.
Because when you are looking at the merit, let us assuming that I am condoning delay of 731 days, as in case of Mr. Das.
Yes.
The other one is 301 days. But what about merit? The eyewitnesses do not support.
Lord, keep it to some other day. My lord, merit on merit, I am not actually.
So now, after looking into merit, I am neither condoning delay. I am not condoning delay. Also on merits, I am observing.
If merit is there, my lord,
if merit is there, then also because I will also go into the merit.
Yes,
because that is my understanding.
That will be approved.
While condoning the delay, because if you are saying that substantive justice and some irreparable injury or whatever way you put it, whatever language you use, I am not getting the exact word. But if there is no merit, then what is the point in condoning the delay of 731 days?
Yes.
And one line of explanation that at different stages, at different levels of government department, it has to be considered.
Yes.
Who is doing that actually? Who is doing that? What for then? Then the propriety of the consideration is to be considered. Mr. Standing Counsel for the petitioner, Mr. H.K. Mahanto for the opposite party, and counsel for the petitioners. How much time, Mr. Standing Counsel?
Well, your lordship, if your lordship will hear, my lord, then next week.
The Lord Standing Counsel seeks accommodation to advance arguments.
Well,
he is requested to go through the judgment apart from advancing arguments on the miscase for condonation of delay. Yes. List on 22nd.
Yes.
22nd, 11/2023.
both delay condemnation as well as merit.
Whenever you are arguing on delay, please
Yes,
look into the
we'll
case.
come. My lord, in order to avoid unnecessary delay, we'll come.
Yes. And this right is statutory, Mr. Standing Counsel. It's not cannot be, because the consistent view of the Supreme Court is that wherever there is a delay and the right has accrued in the other side, then it has to be tossed. But I mean, this has to be overturned, but not in such a casual manner. Since state has come, so let us condone 700 days delay.
Substantial delay.
Substantial delay is fine, but there has to be some case in the otherwise merit in the matter. Yes, next.
63.
Same thing. Same thing, my lord.
But Satyavrata Panda has not appeared today. In 2-3 matters, he has not appeared. Mr. Standing Counsel for the state, Mr. Petitioner, opposite party, none. The miscase likhive. Or the delay has been condoned?
No, man.
I issue notice and limitation, yes. The petition has been filed for condonation of delay of miscase election. 264 days. Filing a petition, 264 days delay and filing the petition. None appears for the opposite party to respond to the learned Standing Counsel for the petitioner to grant further opportunity. List on 13 December. Yes, next.
64.
Again, 11 years, no service return. You take fresh step.
Yes.
Mr. Standing Counsel for the petitioner, Mr. Opposite party blank, the miscase election. The office note put up by the registry indicates that service return of notice in limitation matter issued to OP number 1 and 2, not yet complete, nor any appearance memo has been filed. Office note date ta pakeve. Office note dated 9/11/2020.
Here, my lord, delay.
Delay.
Only 29
Delay of 29 days.
29 days.
One day we cannot be also condoned without hearing them.
Yes, my lord.
The learned Standing Counsel seeks leave to take notice afresh to the opposite parties in present correct address. Prayer is allowed. Let notice be issued to the opposite party in present correct address.
4 weeks.
Present correct address. Requisites be stopped. Requisites be filed for issuance of notice by registered post with AD within 4 weeks. Yes, next.
65.
May I please, your lordship?
Yes.
In 65.
If your lordship permits, my lord. Sir, good minute, yes. Lord, in this case, my lord, the state vigilance has preferred this petition seeking leave of this court, my lords, to appeal against an order passed by Lord Triad for acquitting all the 5 accused persons, my lord. In this case, my lords, I'm sorry, my lords. Yes, 5 accused persons, my lord. And before I place the petition, my lords, if lords turn to the miscase I have filed for condonation of delay, my lords.
Yes.
My lords, unfortunately, my lords, it contains only
routed through different departments.
The movements of different departments in a my lord, in the process of getting consultative processes, my lord, delayed the matters, except that no other cause and reason has been ascribed for which the petitioner was prevented by sufficient reasons. But with regard to the merits of the case, my lord, if you also turn to page 2 of the petition.
Yes.
Page 2 of the petition. The background is that one Bhaskar Samal was the principal of Added College, my lords. Thereafter, my lords, Jantra Parakit is the accused, my lord. He continued as the principal of the said college from 6/9/94 to up to 7/7/95 during the tenure of this the accused, my lord. And vice principals of Valna Panda also continued the said college. It is alleged that they connived with 2 local candidates, Madhusudan Sahu, Ravindra Kumar Sahu, and appointed as storekeepers by the college by fabricating antedated appointments dated so and so. And we'll also turn to the next page. The another reason is that they were not the science graduates. Not the appointment of the storekeeper in science faculty is that the candidate must be a science graduate. These are the backgrounds, my lords.
Yes.
The Law and Trial Code, my lords, passed the orders, and they were let off primarily because of the reasons ascribed in paragraph 24 of the judgments. Because PW 3, 2, 9, and 10, my lords, they have deposed that nothing against the accused Kushta Chandra Maharana, my lords. They are not one of the accused, my lord. And PW 9, 10, 4 is also not worthy to credit or prove and establish the head clerks Kushta Chandra Maharana.
Yes. Here all the opposite parties are alive.
Yes, my senior appeared.
Parija, I am in one matter, the one has expired. But all your clients, you have received instruction.
I am only for only 5.
I am only for 1.
No, total 5 accused persons are there. By now, upon ketna
One.
So Das is 1. Das is 5. Mr. Parija is 1. Then what about other?
They have not appeared.
No, notice.
But anyway,
so
since there is a common accusation and allegation, what is your submission and merits?
Merit in respect of accused number 1, there is no sanction from the there is no sanction to prosecute against him, because I am placing 71, page number 71, where it has been clearly stated.
He's a principal of the aided college.
My lord.
So sanction is not necessary.
No.
Aided college. No.
So there are two concepts: no sanction, invalid sanction. They said that governing body is a competent authority. Sir, it is no.
There is no sanction from the governing body. It has been held, and it has been held that
no sanction from the governing body is required as per Odisha Education Act section. Because the appointee is always appointments are made by the governing body actually, not by the principal. He may be the secretary.
Yes.
No. He in aided college. He was transferred to Saranpur, where the governing body is the sanctioning authority.
In all colleges. In all colleges, it is governing body.
My lord. So
there is no concept
my
of
humble
the principal appointing anyone. But sanction of the governing body to the extent of sanction for prosecution, you are saying.
My lord.
You are relying on paragraph?
Paragraph 72.
Page 72. Page 72.
Page 70, your lordship will get page 70.
Yes, page 70.
Yes, it is started in course of after 5, 1, 2, 3, 4, 5.
In course of argument, the Law and Defense Counsel.
In course of argument, the Law and Defense Counsel has argued that admittedly the accused persons are public servants, and to prosecute a public servant on section 420, 468, 171, 477A, 120B IPC, sanction on section 1797 CRPC is necessary. But in this case, there is absolutely no sanction on section 197 CRPC. But I am unable to accept such contention of the Law and Defense Counsel because the accused persons are principally charged on section offense on section 13.2 read with section 13.1D of the PC Act. And
exact point is 73.
Alleged charge under section so and so. And when sanction order has been obtained,
that you read slowly. And when sanction order has been obtained for prosecution of the accused persons under the provisions of the PC Act.
Yes, my lord.
No separate sanction order 197 CRPC under accused persons, different IPC is necessary. So sanction order has been obtained, Mr. Parija.
No, not.
Lordship permits me not the exact
sanction.
Sir, got to mention, sir. Lordship, turn to page 73, notes. I am placing just the paragraph above paragraph 29.
Yes.
The paragraph starts above 29. PW3 to accord sanction for prosecution of accused Ravindra Kumar Swai, Madhusudan Sai. The sanction order given by PW3 is invalid without jurisdiction and operative. So the prosecution has succeeded.
Vitiated. Not succeeded, vitiated. The prosecution under PC Act is vitiated.
And Lord's way, turn to the subsequent line. Without jurisdiction.
Why the court says that it is the invalid sanction?
71 page last time.
That Mr. Parija is perhaps saying that it is no, it has never obtained from the governing body.
My lord. It is clear stated in 71 page. He should have accorded sanction for prosecution for Jantrana Parikit as president
Of course,
Nilabara
PW
College.
13, the last but about 8 lines, it reads, of course, PW 13 in his cross-examination has stated that he was also the president of Nilamadhava College, but he should have accorded sanction for the prosecution of Jantrana Parikit. He is Jantrana.
Accused.
Now
The principal in charge.
It's accepted name. You know,
I have heard for the first time.
I have also heard for the.
His real name is Parikhitananda when he was reading in Ramja College. But after that, he changed his name Jantrana Parikita. That is.
And not as president of Saranakulu College.
Yeah, that is the point.
But this entire episode of allegations is of Saranakulu College.
My lord.
Yes, Mr. Das, it is from Saranakulu College.
My lord. For Saranakulu.
No.
So what is the other reason?
Nilamada Contilo was established in 77, receiving grant inmates from the government 84. Bhaskar Samal was the principal, and he resolved in governing body to appoint 2 storekeepers. And but neither in Tribune or in the Jantrana Parikit continued as principal of the state college from 94 to 95. During his periods, my lords, it is alleged that they connived with 2 local candidates, so and so, and appointed them as storekeeper without their science qualification, fabricating antedated appointment. These are the allegations. Lordship, record the findings of the learned trial courts. That so far, the another finding is PW 9, 10, 14, not OD to credit.
Sanction part is
period of the sanction pact.
Then what other evidence?
That is at page 62. Page 62, that judgment, page 62. And my lord, another.
In fact, I think the learned court has not proceeded any further. Once it is found that there is no sanction, they have not gone to examine the evidence.
That evidence has been examined in paragraph 24, notes. Paragraph 24, but if lordship turn to the next page, page 61, paragraph 24, page 60, the next page is 61. It starts PW2 so and so, PW3 so and so, PW12 and PW are the teaching and non-teaching staffs of the Nilamadhava College. None of them except 9, 10 and 14 have deposed anything against accused Krishnachandra Mano. These are the foundation for letting him. Krishnachandra Mano, though thereafter, second finding is the next page in the same paragraph notes that therefore, the evidence of 9, 10, 14 is not worthy to create the proof and establish that head clerk Krishnachandra Mada was custodian of the dispatch register. And the writings at page 46. So paragraph 24 contains the findings and discussion with regard to the evidence of different PWs and the trustworthiness of that evidence. Thereafter, he turned to the factum of sanction.
Item 65, miscase 57 of 2012. The miscase has been filed by the petitioner state for condonation of delay of 322 days in filing the petition seeking leave under section so and so of CRPC. Seeking leave to appeal. On perusal of the grounds taken in the petition, It is indicated that the delay has been tried to be explained that the file that the file has to be routed through different departments of the state for which requires considerable time to take a final decision by different departments of the state whether leave application to file appeal against the acquittal shall be filed. Quote ends. This is paragraph 2 in Miss case. Paragraph 2 आज लिखता हूं, देखिए लिखो. In considered opinion of this court, in view of the settled position of law as laid down by the Honorable Supreme Court in 2012 3 SCC 563, repeat those decisions. Movement of file taking lot of time is not a valid ground to condone the delay, as the petition doesn't disclose that there are sufficient ground by which the petitioner was prevented from filing the appeal. The miscase seeking condonation of delay fails. Apart from rejecting the petition for condonation of delay, this court has occasion to go through the judgment rendered by the learned trial court, copy of which has been annexed to the petition. The learned trial court has gone to a great length in dealing with the evidence presented by the prosecution, particularly the statements of the prosecution witnesses as well as the documents. That leave part is at page 71. Regarding the
Evidence of
regarding the sanction granted for prosecution against the opposite parties, the following finding has been given. Page 71 of the judgment, internal page, which reads as thus. Of course, PW 13 in his cross-examination has stated that runs up to page 72 is illegal and without jurisdiction, and is inoperative because as per settled principle of law and as per several judicial pronouncement, the place of occurrence and not the place of subsequent posting on transfer is the place of according sanction. This I was asking Mr. Das, that where it happened and where they granted sanction. Maybe they in good faith they did this, but it's a fatal error.
But that never ended with the perversity. Lordship may indicate, because only one grounds for which interference is required or warranted, if there is any perversity, if the findings is against the weight of evidence. In this case, there is no contradictions.
The said aspect of this aspect of there being no legal sanctity as far as the grant, the sanction for prosecution is concerned, has not been seriously challenged in the present leave petition. The learned counsel appearing for the OP number 1, Mr. N.P. Parija, as well as the learned counsel appearing for the Mr. OP5, Mr. Das, Vivendra Das.
OP5.
OP5, lecture, OP5. Likhile, OP5, Mr. Das. Submit that no material has been brought before this court to show that there has been non-consideration of material on record, or there is any perversity as far as the finding of lack of sanction is concerned. Further, the learned trial court has also dealt with the statement of the other prosecution witnesses. To give to return a finding. Sorry.
Last paragraph, page 73, last paragraph.
Yes.
From the above facts and circumstances.
Yes, that's the conclusion. But I'm
Yes.
looking at the evidence.
Yes.
To return a finding that the persons, the opposite parties cannot be held guilty of the accused, held guilty of the alleged offences. In view of the above discussions, in contrary to opinion of this court, no case is made out for continuation of delay. Also, the petition seeking leave to appeal is otherwise devoid of any merit, and accordingly the same is dismissed. Yes.
66.
Petitioner none. Opposite party 66. Mr. Standing Counsel, you are there. 66. 64.
Yes.
Mr. Standing Counsel for the state, none appears for the petitioner when the matter is called. The petition was filed in the year 2012, challenging the order passed by so and so in so and so. Details like given. On 36/2012, the matter was adjourned by the learned counsel for the petitioner, and again it was adjourned on 19/7/2012, 4/10/2012 by the learned counsel for the petitioner. On 1/11/2012, none appeared for the petitioner. Thereafter, on 19/11/2012, the learned counsel for the petitioner sought for adjournment. 1911 लिख रहे 1911, 6/12/2012, 15/1/2013, then 28/1/2013, After the petition was converted to criminal revision by order dated 8/5/2013, it has not been taken up oblique listed oblique taken up till it is listed today. The defect pointed by the staff reporter is that after the said order dated 8/5/2013, the consolidated criminal revision petition has not yet been filed. Apparently, the petitioner has lost interest in prosecuting the matter. To grant further opportunity, list on 28/11/2023. Or Mr. Standing Counsel, what can be? He's not filing the petition.
Well, copy is not there. Otherwise, I could have assisted your lordship.
No, I'm just asking. He's not filing the petition even after 10 years.
That's when he's not removing defect. That can be taken care of.
Another no, that liberty has been granted. She still is not removing it.
Lord, may I issue peremptory?
Or yes, let it come on 2811. Let us use.
67.
Petitioner none. Mr. Bhanjadeo. Petitioner none. Mr. Standing Counsel for the State. None appears for the petitioner when the matter is called to grant another opportunity. List on 2911.
For removal of defect, my lord, your lordship.
Yes.
68.
Mr. Pratap Kumar Mohanty for the petitioner. Mr. Standing Counsel for the State. Learned Counsel for the petitioner submits that due to inadvertence, he could not remove the defects as pointed by the SR, staff reporter, and prays for further 4 weeks time. As prayed for 4 weeks time granted to remove the defects. List after SR. Yes.
69.
Mr. R.K. Satapathy for the petitioner. Mr. Opposite party blank, State Bank of India. But blank. The Learned Counsel for the petitioner for petitioner submits that he shall take steps for issuance of fresh notice, for issuance of notice afresh to the opposite party in view of the office note put up by the registry that the notice has been returned unserved due to insufficient address. Prayer is allowed. Let notice be taken. Let notice be issued afresh by registered post with AD, requisites for which shall be filed within 7 working days. Yes.
70.
Mr. N.R. Patnaik, Mr. Nihar Ranjan Patnaik on behalf of S.K. Purohit for the petitioner. So opposite party blank, the Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for. List on 8/12/2023.
71.
Your Lordship, item 71. I'm appealing to Your Lordship. Your Lordship, on behalf of Mr. Sarthak Naik, I'm praying for an adjournment, Your Lordship.
One is there on behalf of Sarthak Naik for the petitioner. Opposite party blank. The Learned Counsel for the petitioner seeks accommodation to obtain instructions as prayed for. List on 18th of December 2023.
Much obliged.
Name of Mr. Naik be indicated in the cause list as well as the case brief appearing for the petitioner.
I'm much obliged.
I pray for my lords, 2 weeks time, my lords.
Mr. Sangram, the Standing Counsel for the State.
Indicated 2 defects, my lords.
Petitioner, Mr. Opposite party blank. The Learned Counsel for the petitioner seeks accommodation to remove the defects as pointed by the SR as prayed for. 2 weeks time granted to do the needful. Yes, next.
73.
73. Current address Meduni.
Another 4 weeks my kindly.
Mr. Standing Counsel for the State.
We should letter.
Mr. Opposite party blank. As per the office note put up by the registry dated 10/11/2023.
Here also, my lord, the lordship may keep
Indicating
it
that the fresh steps for issuance of notice has not been taken. The Learned Standing Counsel seeks further accommodation to take steps for issuance of notice. He submitted that the matter being old one, the current address has not yet been obtained and further time may be granted. Prayer is allowed. 4 weeks time granted for taking steps for issuance of notice afresh to the opposite party in the present correct address. Yes.
74.
74, my lord, the rest has indicated a project onto the notings appended to item 74. No AD or Baklato receipt on behalf of the opposite party, not 2 lords.
So you will take fresh notice.
Fresh notice.
I think OP1 has appeared.
But
Your
no,
Lordship,
but
I'm appearing on behalf of the OP1, Your Lordship.
for 2,
But
I'll take fresh.
there's 2, it has to be notice to be issued afresh. Your name?
Your Lordship, I'm appearing on behalf of S. Patnaik.
What's your name?
Tamanna Patnaik. T. Patnaik.
Mr. Sangram Das, Standing Counsel, 74 election. Sangram Standing Counsel, opposite party number 1 none, OP2, Tamanna Patnaik on behalf of S. Patnaik. M.S. T. Patnaik on behalf of S. Patnaik.
By rest
The
report.
learned counsel for the learned standing counsel for the petitioner state submits that he may be granted leave to take notice afresh to the opposite party number 1 by registered post with AD in the present correct address.
I think 2 lords.
In the present correct address. Prayer is allowed. Let notice be issued in the present correct address. Requisites for issuance of notice by registered post with AD be filed within 3 weeks.
My lords.
Yes.
75.
25, my lord, IA has been filed for correction of order, my lords. The maintenance case number is 252 of 22.
IA sir 91 of 2023.
Yes, my lords.
The IA 91 of 2023 lekhonto. The application, here this order was passed by me.
My lords.
The application for correction of typographical error has been filed, indicating that inadvertent typographical error has crept in. It is mentioned correctly in the petition.
In the petition, it is wrong, my lords.
Been wrong.
Yes.
Then how it is a typographical error?
In the IA, well, subsequent IA had filed. In that case, my lord, 252 of 2023 it was mentioned. It should be 252 of 2022, my lords.
So there has been 2 mistakes.
Yes, my lord.
First 252, then 23.
Yes, my lord.
Then I don't know, they will be getting confused and again make a mistake.
Final is CRP number 252 of 2022, my lords.
252 ta ko line re mention hechi ko paragraph?
Paragraph 1, 6 and 7, my lords. Of order dated 3/4/2023.
Oh, that's a mistake. 252 of 2023. Again, you have made a mistake.
Yes.
I likhile inadvertent typographical error. The year of the case mentioned as 2023, that is CRP number 252 of 2023. At paragraphs 1, 6, 7 is to be corrected as 252 of 2022.
2022.
Correct.
Yes, ma'am.
The necessary corrections be carried out in the order sheet, or there is a provision for to print another order sheet. केते थोड़ा correction नहीं परियो गोटे order sheet. Oblique fresh order sheet be printed as per rules after corrections. This case stands disposed of. This is IA. IA stands disposed of. Yes, next.
76.
May I please, Lordship? My lord, railway preferred this appeal, my lord.
Yes.
The case registered for commission offence under section 3 RPUP Act.
Yes.
The London Trial Court acquitted the accused, my lord.
Yes.
My lord, I would like to take your lordship to paragraph 8, my lord.
Of the judgment.
Of the judgment.
Yes.
Now the next point which falls for consideration is whether the property seized.
Actually, it's a little bit hazy. It is internal page.
Internal page 11. Some places also.
You are placing the appellate order or the original order?
No.
There is only one order.
One order. That is the trial court judgment.
There is no page. 11 I could not get. Internal page of the judgment, how does it read? It starts at page
7.
Paragraph kete kuchanti? Which paragraph?
8.
8. Now the next point. Now the next point. Yes, correct. Yes.
Now the next point.
Here I don't have a page mark. This is showing 42 or something. Yes. Now the next point.
Which falls for consideration is whether the property seized belongs to railway. It clearly lays upon the opinion of the expert. The prosecution case examined PWC who opine on the articles produced before him.
Yes.
Yes. He also stated that they were serviceable material not available in the open market. He also draw the attention towards the number drafted on the seized article. It was specially designed as per standard of railway research and design standard organization Lucknow at the SO. Hence, his evidence is found unimpeachable in its
incisive spelling mistake. It's not incisive. That is incisive cross-examination. Nothing worth was brought out. But the evidence of the expert opinion is only corroborative piece of evidence. Without the existence of substantive evidence, it has no role to play.
My lord.
Then what is the substantive evidence?
My lord, substantive evidence, my lord. The Lord Trial Court kindly have a glance to paragraph 6, page 9. So it is
M.S.Sahoo has not been examined. Confessional statement.
That is the police officer who accompanied the railway officials to the spot.
Yes.
Trial court disbelieved that police officer was not examined and the independent witness they turned hostile.
Then how do you prove it?
My lord, it is settled that it is a railway property, my lord.
Sir, seizure part apana kochunje, but how do you prove the offense committed by these persons?
My lord,
the material object that was produced was proved to be railway property.
My lord.
But that property was seized from possession, or they say that as per your statement, as per your acquisition, that it is a confessional statement before Mr. Sahoo and Mr. Mahalik.
My lord, that was the property was
actually that was see the way the judgment has been written, maybe what you are taking advantage of that. So whether this expert opinion is impeachable or unimpeachable, how does it matter?
It is proved that it is a railway property. So
property is railway property, but it is the possession has to be proved.
No.
Possession and or the confession has to be proved.
The confession could not be proved, my lord.
Seizure, can't prove
seizure, all the official witness, they have stated that it was seized from the house of the accused, my lord. All the official witnesses.
And it is a case of attempt or what?
No. It was committed. The accused is a blacksmith. He was in possession of the railway property.
Preparing some iron equipments.
My lord.
Then you have to prove the possession. Then the more so.
That paragraph 7 is material. My lords, may kindly have a look at paragraph 7.
So paragraph 7 that I drawn Mr. Naik's Partho Sarathi Naik, Devashish Naik, both are Naiks. From the side of prosecution, 2 constables, namely, you are referring to that. M.S.Sahoo and D.S. Mahak cited as witness to the confessional statement of the accused. The constable RPF M.S.Sahoo has not been examined by the prosecution during the trial. As per B.B. Mahak, on 3/1/2001, he accompanied the SI of RPF and apprehended the accused. In his cross-examination at first, he stated that the confessional statement of the accused was recorded in RPF office, but subsequently he stated that it was recorded at village Maliguda. Then he was not in custody actually.
Not custody.
Village re jaiki tanga ghare bode pahunchile. Then there is one evidence that he ran away from the spot. So that is why I was asking, it is a case of attempt or what?
No, no, it was recovered on seeing the police. The accused ran away from his house, and the property was seized from his house.
If you read paragraph 7 from the beginning, just further PW4
Further,
stated.
PW4 stated in his examination in chief that he searched the
shop of the accused,
and on search he recovered 2 number of RC bearing plate.
Yes, not
Ring
visible
number.
clearly. Not visible clearly. Some bearing plate, bearing number RT 1040.
1040
and one caught piece of rail line measuring length about 2.5 feet, having 3 holes. ये जो source किए witness किए prove कला आकु ताको दुकान रे.
This railway official, those who are present at the time.
ସେମାନେ PW केते?
PW, my lord, I'm placing PW.
ସେଇଥିରେ ଦେଖନ୍ତୁ. No. ଆପଣ ଯିବେ witness ଯେ, but how the court has gone into that. ଆପଣ just ତାପରେ ଦେଖନ୍ତୁ. Just read further. On the other hand.
Thereafter, he seized the recovered property. PW4 seized the recovered property
in presence of available witnesses.
Available witness. On other hand, the witness to the seizure.
Witnesses. ମୁଁ actually একটু enlarge କରି ଦଉଛି.
Seizure
ଆପଣ
witness.
enlarge କରି ପାରିବେନି? ମୁଁ 138% ଦେଖିକି ତାକୁ ପଢୁଛି. So the witnesses, yes. Then read.
Examine PW6 and 7. The independent witnesses did not support the case of the prosecution.
So ଏଇ ଜିନିଷଟା ତ ସେ prove କରିନାହାନ୍ତି ତା ମାନେ.
My lord.
ଆଉ ଯଦି prove କରିଛନ୍ତି ତାହେଲେ ଆପଣ ଦେଖାନ୍ତୁ.
Both the independent witness, they have not supported.
Because here it was not recovered from his possession.
From his shop.
It was seized from his shop. So you have to prove the seizure at least. Seizure witness ରହିବା ଦରକାର. ସେ ଆପଣଙ୍କର seizure list ରହିବା ଦରକାର. They have to sign.
The Sarpanch in his evidence stated that he has given the certificate that shop is belongs to the accused.
That is not enough. Shop belonging is not disputed even. Then you have no case. Who is disputing that shop? It doesn't. Shop is not. Shop is, but it was seized from his shop, that article, and this seizure was not contaminated. What they call sanctity of seizure. That you have to prove. Say
independent witness, they have not.
Then let us assume that so actually the first part has gone. So that is how they are relying on the confessional statement. Then the confessional statement by the witnesses Mahakau, that Sahoo, they have not supported. So that is how the learned court was referring to the expert opinion. Whatever is produced as seized material, the material or the alleged this recovered material is railway property. That is not disputed. But where from it is seized, that is not proved.
That is not.
No delay. Already delay condoned.
Delay condoned.
Delay condoned. Mr. Parthasarathi Nayak for the petitioner. This is item 76. Mr. Parthasarathi Nayak for the petitioner.
Senior Panel Counsel, Union of India.
Mr. Senior Panel Counsel, Union of India, into bracket railways for the petitioner.
Accused to appear करनाहांती.
LP रे आपणकर एटा तो कन्वर्ट हेनी
ना
आपण आपन के डिपोजिशन कॉपी अछि की कुड यू फाइंड एनीथिंग मोर देन दिस
ना
the learned counsel for the learned senior panel counsel refers to the earlier order. The upper first paragraph, the petition has been filed so and so. The delay having been condoned, $500 cost दे दीचंदी.
Previously
that you have to give. There is an order. A receipt showing payment of 500. Yes. Advocate Welfare Fund. The delay having been condoned as per the order dated 11/8/2003 and the condition imposed for condonation of delay, that is deposit of ₹500 to be deposited in the Advocates Welfare Fund of the Odisha High Court, having been complied with. the learned senior panel counsel addressed arguments in merits of the case. The notices were issued by order dated 24/10/2008 on the question of admission. The office note dated 11/1/2011 indicates that service return of admission notice issued to the sole opposite party served personally and reported to be sufficient. None appears for the opposite party when the matter is called. The learned senior panel counsel refers to the judgment rendered by the learned trial court to advance arguments, particularly the fact that the expert witness, that is PW so and so, has proved that the PW3 has proved that the property which was allegedly recovered from the premises of the opposite party is railway property. The learned trial court has believed the statement of the expert witness PW3 to return a finding that, as per his opinion, the railway properties were produced alleged to have been recovered from the opposite parties. However, the further fact of the case is that the prosecution witnesses, namely PW6 and PW7, regarding recovery of the property from the possession of the opposite party, have not supported the prosecution case. It is noticed that both PW6 and 7 are independent witnesses. The official witnesses, that is railway constable, they're constable, na?
SI and constable.
Who is SI, who is constable? The sub-inspector of police, railway. PW1
status টা দেখি দিচ্ছি।
এসে যেটি লেকচার এসে যে mahak जो नाडा mahak and Sahoo.
PW1 is the head constable.
The head constable, PW1, and constable, PW, and another constable. जो दी जन specifically आपण साइट कॉलेज एमाने they have witnessed, but they are not supporting. गोटा हाईलाइट करथिल जे पेटा लिभि जाई छी. NP Sahoo, yes, it is there, not sorry. NP Sahoo केते और DS Mahak केते number witness? NP Sahoo,
they are not cited as a witness, my lord. Even though
अच्छा, you did not examine. Sorry, कौन लिख ले? एसेटा काटी दियंतु. तापर ता पूर्व सेंटेंस ता कोड सरले कहले. It is noticed that 6 and 7 are independent witnesses. The further finding given by the learned trial court is that though the prosecution initially proposed two of the railway constables,
they are police
constables, same thing, railway police are, because he's in fact, he has filed the case. Now you are appearing. The police constables cited as initially as witnesses to the confessional statement of the accused regarding his possession of the railway property have not been examined as witnesses. Para. In view of the above, in considered opinion of this court, there being no material irregularity or perversity in the judgment of the learned trial court, the present case is not fit where the leave should be granted for appeal, and accordingly the CRLLP stands dismissed. Yes, next.
Mr.
Pratap Naik on behalf of Kirot Kumar Raut for the petitioner. Opposite party blank. The learned counsel for the petitioner submits that as per the instructions received from the petitioner, he doesn't want to press the present petition. He doesn't want to proceed with the present matter. Memo dated 13/11/2023 filed by the learned counsel for the petitioner is taken on record. The petition stands disposed of. '78.
Wife's application
Yes.
for enhancement of the maintenance,
Yes.
which was granted rupees 2,000. Though he is a government servant, my lord, earning more than 20,000.
There's this revision will apply in 401 and CRPC, 125 CRPC.
120 ne seita pain nue. 401 ta hochi concurrent jurisdiction.
Yes.
Sessions court as well as the High Court.
Yes.
I have preferred High Court.
Okay.
Here, your lordship, two revision. In first revision, I am for the opposite party, and in second revision, I am for the petitioner.
Petitioner, yes.
Petitioner husband, your lordship.
Yes.
I pray for next week, your lordship.
What is the present status? Upon arrear kete achi? Stay nechanti ki nahi?
She will not get anything, your lordship.
Your learned colleagues have, I can tell the name even.
Your lordship.
Conscious of that, they are on suo moto, they are saying that I will deposit this.
Your lordship, kindly glance.
Last order dekhuntu, upon jo stay nahi thibe, kete order hithibo.
She will not get anything.
High Court, this court never grants such stay without deposit of some amount. Upon kete debe, that's another thing.
नहीं जमा पाइबेन से आउ जन को पाखरु मेंटेनेंस नउ जंती
को केस रे
से आउटे 125
These documents have been filed directly in the High Court. They have not filed those documents before the trial court.
Then my more judgment tale mu kemdi apana fresh document kemdi file kala. Apana you should have filed those things whatever was there before the learned trial court. How can I take note of that?
We have get the document.
That doesn't help. Apan ko plea thila ki?
Subsequently.
Plea, sir. What was the plea?
Yes,
what was your plea for refusing maintenance?
And they have admitted that she is the legal married wife.
Subsequently.
You see, Mr. Mahanta, that plea was not there. Then there is no plea. You see, the issue could not have been framed. Much less evidence could have been produced.
That is expertise order, your lordship. And I have in my case, I have annexed all the document, your lordship.
Apanaka matter re apana stay nahi chanti. Jothre apana petitioner, Mr. Mahanta, you have taken stay order. Which order? Distress warrant hechi se tere execution na stay hechi. Apana deposit kariya katha. 125 order ta apana merit re challenge karchinti na nahi?
No, your lordship.
Then how to proceed in the matter also? How the court can proceed? You take instruction. If you are agreed by that 125 order, you have not challenged.
No.
In your defense, as far as her case is concerned, the wife's case is concerned, you are citing that 125, another case is there. That was not part of the record before the. In fact, you have not taken the plea also. Then how this court can proceed on that, on basis of that?
But I have annexed in my petition that she is getting from another person.
That is.
I'm not very clear. You see, I'm not very sure of my jurisdiction that I will take note of everything. I cannot do that.
जो डॉक्यूमेंट देबे आगे सेटा तो पुनी मु प्रूफ
Obviously, there is, but I mean the even going to a further extent, did the learned court consider that to give any opinion either way? Then how this court will proceed?
Your Lordship, taken up next.
See 125. I don't know because in Hindu Marriage Act maintain that is a 15 or 15.3 that is there.
ना हिंदू मैरिज एक्ट रे सेटा होची सेक्शन 28
No,
that is maintenance
modification.
pendant right
28.3 जो modification फाइल हुए 28.3 रे कोडे वाला
एटा सीआरपीसी ना
नहीं CRPC मु कोन
आज्ञा
मु पर my poser is whether there is similar provision in 125 CRPC.
हां अच्छी एनहांसमेंट पे अच्छी ये पे अच्छी 126 सब होची मॉडिफिकेशन पे अच्छी
126 रे तो मु जो स्टे देनी केबे भी सेतरे को अलाउ भी केबे करिन because she has a right to maintain it everywhere. But there is a provision in Hindu Marriage Act that subsequent petition can be filed for modification of the quantum of maintenance.
हां सेटा अच्छी ना
Even for stoppage. So you should have filed that so that in that case your prayer being rejected, you can challenge it in the High Court.
Variation
You are in this case your plea is not that she is not your legally married wife.
No, subsequently that come to our
Whatever it may be, subsequent or that is not correct. That's not a relevant consideration. That's not a relevant consideration.
हिंदू मैरिज एक्ट रे आगे खाली पेंडेंट लाइट अछि एटा हिंदू अडॉप्शन एंड मेंटेनेंस एक्ट कहउछन आपण
25.3 I am right 25.3
नहीं 27 रे भी अछि 127 127 रे
25.3 अछि 25.2 अछि so now the bar has educated that 20.127 अछि in 127 petition adverse order against you can file and make a this prayer not in 125. But somehow you have persuaded. Anyway, so apan kebe chahunchant?
Next week and
you often discuss with your senior and often instruction. But maybe you are not getting instruction from the petitioner. But I think if there is a 127, then this prayer is already. I mean, and 25.2.3, if it is there, taking the note of these conditions only, that she has not remained so and so, she has got married and all these things. 127 रे से condition थी वो.
नहीं 125 रे अछि जदि से expertise हेतो he can file an application to set aside that expertise.
127 alteration in allowance, right, Mr. Standing Counsel? On proof of change in circumstances of any person.
This is 125 टा होचे the expertise हेतो.
But 127 examine kari dekhontu. I think that's the only way out because you have missed that opportunity also, and now it is stayed since so many years. Mr. H.K. Mahanta, in the first matter, Mr. 78, Ms. Pali Mahapatra for the petitioner, Mr. H.K. Mahanta for the opposite party. You write MOHA. MOHA Mahanta, MOHA NTA. Mahanta for the opposite party. The learned counsel for the opposite party seeks accommodation to obtain instructions. The learned counsel for the petitioner submits that the C has not been paid the maintenance allowed by the learned court below. How much you are not yet after this proceeding, during pendency of the present proceeding.
नहीं मूलुर आगे नहीं नांती. Distress warrant issue.
Distress warrant. And the second matter lekhontu 941. As prayed for date kebe chahunchandi Mr. Mahanta?
Next week will open.
List on 28. Today is 13. 28. 28/11/2023. Mr. H.K. Second matter lekhontu CRL REV 941. Mr. H.K. Mahanta for the petitioner. M.S. Dipali Mahapatra for the opposite party, learned counsel for the petitioner submits that certain developments has come to his notice, who has filed which has been filed before this court. That is, the opposite party wife is married to somebody else.
सेटा आज्ञा 125 परे हेई नै से पूर्वरु कहउछन्ती 125 ପିଟିସନ ଟା ଫାଇଲ ହେଲା ପୂର୍ବରୁ ମୁଁ ଆଉ ଜଣକୁ ବାହା ହେଇଥିଲି ତାଙ୍କଠୁ ମେଣ୍ଟେନାନ୍ସ ନଉଛି ବୋଲି କହୁଛନ୍ତି।
ତାହେଲେ ସେଟା ଇଲାବୋରେଟ କରିବାନି କଣ ଲେଖିଲେ? Which has been placed in the present petition. Certain developments that those have been placed in the present petition would indicate that the opposite party wife is not entitled to any maintenance as under section 125 CRPC. The learned counsel for the opposite party as well as petitioner in the connected petition CRL REB 507 of 2013 submits that such material is disputed, and assuming that such material is there, the same should have been brought before the learned court in session of the matter, in season of the matter, and having not done so, such ground is not available to be taken in the present petition. The learned counsel for the petitioner seeks accommodation to obtain instructions as prayed for list on 28/11/2020.
Case matter as per you.
This is computerized. This cannot be interfered with. Also, please mark that this is the matter of 2013, and somehow the list starts with 2006-7. So this can be altered.
12 13 रो हिच ना फ्रेश मैटर
आपनकर जो ऑर्डर्स आछि बेल ये तो कैटेगरी एटा फॉर एडमिशन रे आछि एटा फ्रेश करी होबनी से कंप्यूटराइज सिस्टम रे ताको
फ्रेश आपण ऑर्डर कर देले हे जो
it will come upon asu seta upon you can mention information mahanta also, and usually all the matters are reaching. I am not saying that being taken up. I understand we are well past the time. I understand. I understand.
Intimodern in my case
upon agur jodi extend any korantoni after ASEAN resurfacing, these matters are not to be extended. Twice order of Supreme Court, High Court has noticed the order of Supreme Court, then how I can extend it? Jodi agur extend heitila last date re tale khunda apon dekhla 10 varsh tale heitio. That is the problem. Apon ko interim order bodhe achi eta 941 ta. I can tell you what is the date of interim order. 9 varsh. Exactly 9 years, 9.5 years. Thereafter, it has not been taken up or listed. You may say that it was not listed, so let it be there. No, there is no, at least no order varying this interim order. Yes, next.
79.
This Mahapatra, if he often obtains instruction that some amount will be deposited, then he will seek withdrawal of this petition to move the appropriate court. That is a possibility. So you can also think in that line. The rest of the matter, since already time is over, anyone, if any mentions, please mention.
Very well.
The mention would have happened.
89.
Ms. Pragya Mahanti, on behalf of for the petitioner, opposite party blank, the learned counsel for the petitioner submits that during pendency of the petition, unfortunately, the petitioner has passed away. Memo dated 13/11/2023, filed by the learned counsel for the petitioner, stating the same, is taken on record. The petition stands disposed of.
90.
Mr. Himanshu S. Mishra, Himanshu Shekhar Mishra for the petitioner. 90, Mr. Standing Counsel, Mr. Naik, Mr. Devasis Naik, AGA for the state opposite party. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 12/12/2023.
94.
Mr. P.K. Malik, on behalf of the petitioner, opposite party. 94, Mr. S.S. Mahapatra, additional standing counsel for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 14/12/2023.
95.
Mr. R. Das Naik for the petitioner
Mahapatra.
Mr. S.S. Mahapatra, AC for the state. Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 15/12/2023.
99.
Mr. Basudev Misra for the petitioner. Mr. Standing Counsel, T.K. Praharaj for the state. Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 13/12/2023.
My lord, item number 96.
Yes, 96.
96, I pray for an adjournment for 3 weeks, my lord.
Your name, sir?
My lord, my name is Asim Kumar Das on behalf of Mr. A. Das.
Asim Kumar Das on behalf of A. Das for the petitioner, 96. Mr. S.S. Mahapatra, Additional Standing Counsel for the state. Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions from the petitioner as prayed for list on 13 December 2023. Thank you.